morning. This is the first day of the hearings, the public hearings for the Wingecarribee Shire Council public inquiry. I'll just take appearances before we commence. Mr. Parrish.
Commissioner Parrish, I therefore, as the council assisting, and I am assisted by Ms. Warren Houston and Ms. Broad, I might just inquire for
Yes. Yes, thank you. Mr. Riley? No need to stand. Yes, I've been given, I'm sorry to cut over you, I've been given a list. I understand that there may be an application by one or more to be dealt with in private session. Is that still the case?
Yes.
All right. I grant you that leave to appear for those. I have 4 on my list. Is that all I should have at the moment? All right. I grant you leave to appear for those witnesses. Is it the case that there may be more as we go?
That's possible.
It's a possibility. All right. None of those people are due to give evidence today. Do you have any other application to make to me this morning?
No, Commissioner. I need to sit in for the rest of the day because I'm here just to the other report.
Yes, you're welcome to stay for the openings. I think that'll occupy most of today, so you're welcome to stay for those. Before we formally commence the proceedings, I acknowledge the Gundungurra and Tharwal people as the traditional custodians of the land described as the Wingecarribee Shire. I pay my respect to elders both past, present and emerging. I would also like to extend that respect to all Aboriginal and Torres Strait Islanders present here today or watching. I'm going to make some opening remarks and then I'll hand to Mr. Parrish to make his opening address. On 31 August 2021, the then Minister for Local Government, the Honourable Shelley Hancock MP, appointed me to hold a public inquiry into the Wingecarribee Shire Council pursuant to Section 438 U of the Local Government Act. Section 438U of the Local Government Act relevantly provides that the Minister may establish an inquiry in relation to A, any matter relating to the carrying out of the provisions of the Local Government Act or any other act conferring or imposing functions on a council, and B, any act, omission or omission of a member of a council, any employee of a council, any person elected or appointed to any office or position under the Local Government Act, or any act conferring or imposing functions on a council, being an act or omission relating to the carrying out of the provisions of the act concerned, or to the office or position held by the member, employee or person under the act concerned. In the lead up to the establishment of the inquiry, there's been a series of ministerial interventions with this council. I don't propose to explore them in detail in these remarks, and I expect that they will be the subject of some attention during the evidence, but in general terms they were as follows. On 19 August 2020, the then Minister issued the council with a notice of intention to issue a performance improvement order. The reasons for that notice being issued were identified by the Minister as being reputational and work health and safety risks facing the council as a consequence of the behaviours of some councillors, that there was evidence of hostility and acrimony between councillors which, if unaddressed, was likely to lead to dysfunction, the presence of behaviours that indicate that some councillors may not understand their obligations under the Code of Conduct when dealing with staff, and the presence of behaviours that indicate that some councillors may not understand their obligations under the Code of Conduct when dealing with each other. On 24 August 2020, an extraordinary meeting of the Council was held to consider the Minister's notice. At that meeting, a resolution was passed that accepted the reasons for the imposition of the performance improvement order that had been identified by the Minister. On 8 September 2020, the Minister issued the Council with a performance improvement order pursuant to Section 438 A of the Local Government Act. The performance improvement order required all councillors to undergo particular training, the Mayor to undergo training in the effective chairing of meetings, and all councillors to participate in a structured mediation process. For that purpose, 2 independent advisors were appointed to assist the Council. On 2 March 2021, the Minister issued the Council with a notice of intention to issue a suspension order. That notice stated that the Minister had formed a preliminary view that the performance improvement order had been, quote, unsuccessful in effecting cultural change in the behaviour of some councillors and in improving relationships at the council, close quote. The notice called for a response by 9 March 2021. In responding to that notice, an extraordinary meeting of Council was held on 9 March 2021. At that meeting, a resolution was passed which, amongst other things, sought a meeting between the Minister, the Mayor, the Deputy Mayor and an additional Council representative to, quote, discuss alternative options to the suspension of all councillors, close quote. Also sought an extension of time to provide a submission in response to the notice until 17 March and resolved that, quote, the Minister take decisive action against those councillors identified by the majority of this democratically elected council who continue not to adhere to the requirements of the Performance Improvement Order, close quote. The content of that resolution was then conveyed to the Minister in correspondence later that same day. 3 days later, on 12 March 2021, the Minister made an order suspending the Council, in substance the governing body, for 3 months and appointing Mr Viv May, PSM, as Interim Administrator. On 24 May 2021, the Minister extended that suspension and with it Mr May's appointment until 10 September 2021. And as I opened, on 31 August, the Minister established this inquiry. In so doing, the suspension of Council was extended along with Mr May's appointment. In establishing this inquiry, the Minister specified 4 terms of reference. They are 1, whether members of the Council's governing body fully understand their roles and responsibilities and have adequately, reasonably and appropriately carried out their roles and responsibilities during the current term of Council. 2, whether during the current term of Council there has been improper interference by the elected body of Council or by individual councillors in operational matters, with particular reference to staffing and planning functions. 3, whether members of Council's governing body have been and will continue to be in a position to direct and control the affairs of Council in accordance with the Local Government Act and to otherwise fulfil its statutory obligations. 4, any other matter that warrants inquiry, particularly those that may impact on the effective administration of Council's functions and responsibilities, or the community's confidence in the Council being able to do so. Those terms of reference have been publicly available since they were announced by the Minister, both in the New South Wales Government Gazette and on the inquiry's webpage. Terms of reference 1, 2 and 3, by their terms, require me to inquire into matters relating to the governing body of Council, that is the councillors, and direct attention to the term that commenced in 2016. Terms of reference 1 and 2 do so expressly. Term of reference 3, which must be read in the context in which it appears, carries the same implication. I pause to note here that I read the reference to elected body in term of reference 2 to be used interchangeably with the term governing body that appears in terms of reference 1 and 3. That those terms of reference direct attention to the term that commenced in 2016 does not mean, however, that events prior to that time are to be ignored. To the extent that there are matters that occurred prior to the commencement of that term that are capable of informing a consideration of later events or provide relevant context so as to permit an understanding of the issues at the heart of terms of reference 1, 2 and 3, they remain relevant. However, the focus of those terms of reference, and thus the majority of this inquiry, is very much the 2016 term. Term of reference 4 is, on one view, exceptionally broad. However, it must be read in the context in which it appears. Although I will hear argument about this if it becomes necessary, my preliminary view is that it would be wrong to read term of reference 4 as requiring a wide-ranging search for any issues or matters that might engage with its terms. Rather, the intent of term of reference 4, as I read it, is to permit a consideration of issues that arise in the consideration of the other terms of reference and which, although perhaps not falling directly within them, may impact on the effective administration of the Council's functions and responsibilities or the community's confidence in the Council being able to do so. I've reached that preliminary view for a number of reasons. They include, but are not limited to, if I were to construe term of reference 4 literally and without reference to the context in which it appears, it would seemingly require me to conduct a wide-ranging search for issues of any kind which may impact on the effective administration of the Council's functions and responsibilities or the community's confidence in the Council being able to do so over an undefined period in the history of the Council, Obviously not enough, that would lead to an inquiry of indeterminate size and length. Not only would that not be an efficient use of public resources, but it would also result in a considerable delay to the resolution of terms of reference 1, 2 and 3. Having outlined the terms of reference, I now turn to make some observation about the nature of this inquiry. Obviously enough, it is an administrative inquiry. That means that the inquiry has a number of features, but also some limitations that must be kept in mind. They include the following. First, the inquiry is confined to the terms of reference. I do not have the power to inquire into matters which, on a reasonable reading of the terms of reference, are not within their terms. Secondly, the purpose of this inquiry is to make findings of fact and, if necessary and appropriate, recommendations to the Minister for her consideration. Thirdly, any findings of fact made by me are ultimately expressions of my opinion as to what the evidence that may be placed before me reveals. Any findings of fact I make cannot and do not determine legal rights. Fourthly, any recommendations I may make are not binding on the Minister. It is a matter for the Minister whether any of the findings or recommendations I may make are to be accepted. I also note that the Minister has powers available to her under the Local Government Act which do not require any specific recommendation by me in order to be exercised. Fifthly, and importantly, it must be understood that I have no power to implement any of the recommendations I may make, impose any sanction, or take any other action based on the facts as I may find them to be. My role is to make findings and recommendations to the Minister for her consideration. It is the Minister's function to determine what steps, if any, should be taken following a consideration of my report. Finally, the rules of evidence do not apply to this inquiry. Accordingly, I may inform myself as I see fit. However, the rules of procedural fairness do apply. Findings of fact should be made rationally and in accordance with proper standards of satisfaction that may well vary depending on whether the asserted factual matter is adverse to the interests of any particular person. Save for Section 13 and Division 2 of Part 2, the provisions of the Royal Commissions Act 1923 apply to this inquiry. Amongst other things, that means persons may be summoned to give evidence at the public hearings and also to produce documents to the inquiry. Both of those things have happened. To that end, shortly after the Minister appointed me as Commissioner, I appointed Mr Angus Broad and Ms Bron Hewson of the Office of Local Government as officers assisting the inquiry. Mr David Parish of the New South Wales Bar was later appointed as counsel assisting. Shortly after the inquiry was established, a call for submissions directed to the term of reference was issued. Some individuals were also directly invited to make a submission. In response to that call, the inquiry received many submissions. Consistent with the approach adopted in other inquiries established under Section 438(u) of the Local Government Act, I have determined not to make the submissions publicly available. There are a number of reasons for that. Again, they include, but are not limited to, the fact that a number of them raise matters which simply fall outside the terms of reference. A number, for example, raise concerns with the merits of particular developments or development applications. It is not the role of this inquiry to examine the merits of individual applications of that kind unless those are matters which fall within the wider context to which the terms of reference are directed. Some authors have, for various reasons, requested anonymity. Finally, some submissions raise matters which are outside the powers of this inquiry to lawfully consider, or raise matters which are not appropriate to be explored in an administrative inquiry of this kind, and accordingly are matters that ought to be taken up with other agencies and not this inquiry. None of that, however, is intended to detract from the utility and assistance gained from all of the submissions received to date. They have been helpful in identifying the issues to be explored, documents to be examined, and witnesses to be called during these hearings. As will be seen by keen observers to these proceedings, there are very many issues that will be explored in the evidence, both in oral evidence and in documentary form. To that end, the submissions are an important and integral part of the inquiry process, and, as is both desirable and appropriate, they provide an opportunity for the wider community to have input into the issues that will be explored. I express my thanks to each of those who took the time and effort to provide the inquiry with a submission. It may be that some individuals who made a submission will be called by counsel assisting to give evidence during these public hearings. Others may not. To those who made a submission but are not called by counsel assisting to give oral evidence, I say this. The fact that you are not called to give evidence should not be taken as an indication that your submission has been overlooked or ignored. It may be that your submission identified lines of inquiry that will be explored with one or more other witnesses, or identified relevant documents that the inquiry has sought to obtain. Every submission that has been received has been given due consideration. In that respect, I am confident that the substantive issues raised in the submissions, and which properly fall within the terms of reference, will be explored in the evidence, both in oral testimony and documentary form. In cases where I have been satisfied that it is appropriate, I've exercised my power under Section 12(b) of the Royal Commissions Act to permit some witnesses to give oral evidence to the inquiry in private session. The reasons for that are varied and relate to the individual circumstances of particular witnesses. That I have done so is part of the ordinary process of an inquiry of this kind. Neither the identity of those witnesses nor a transcript of their evidence will be made public. However, there is nothing secretive or improper about that. That evidence forms part of the overall matrix which I will consider in reaching my findings. On 5 March 2022, I issued a practice direction that sets out the procedure that I propose to adopt for these public hearings. A copy of the practice direction was sent to each of the suspended councillors, those councillors who had resigned prior to the suspension, the interim administrator of the council, the general manager of the council, and it has also been placed on the inquiry's webpage. That practice direction provides that Mr Parish, as counsel assisting, is responsible for choosing the witnesses that will be called to give evidence to this inquiry and the order in which those witnesses will be called. He is responsible for determining which documents are to be tendered and when they are to be tendered. Any person who may be called to give evidence during these public hearings should acquaint themselves with that practice direction. Needless to say, I expect it to be complied with. During the evidence, I may ask questions of some of the witnesses from time to time. It may be that I ask no questions of a particular witness. That is an ordinary function of the fact-finding process. That I may ask or not ask a particular question should not be understood by anyone observing these proceedings to indicate that I have formed a view about an issue one way or the other. I come to this inquiry with an open mind, and final views cannot and will not be formed by me prior to the conclusion of the evidence and a consideration of any final submissions that may be made. In order to mitigate against the risk that these public hearings will be interrupted, and I pause here to note any further, by the ongoing effects of COVID-19, I have determined that it is appropriate to limit those categories of persons who may be present in the hearing room, in addition to those who are assisting this inquiry, to those who are most directly affected by the terms of reference or the evidence that may be given. The categories of persons who are permitted to be present in the hearing room were set out in the notice of hearings, and further detail is contained in the practice direction. The practice direction also sets out the procedure that applies to attendance at these hearings by persons falling within those categories. Any person who believes that they fall in the categories of persons who are permitted to be present in person and who wishes to attend should familiarise themselves with the requirements of the practice direction. It should not be assumed that I will permit a delay to these proceedings caused by a failure to comply with the terms of the practice direction in this or any other respect. I have today received an application from 2 members of the press to attend in person on the basis that their attendance is required to ensure a fulsome and accurate coverage of these proceedings. I have granted that request. If there are any other members of the press who also feel that they are unable to accurately and fully cover these proceedings by viewing the live stream, they should forward their application to the officer assisting the inquiry, and I will deal with it promptly. To ensure that as many members of the public who may wish to view these hearings are able to do so, they are being live streamed. That live stream is accessible on the inquiry's webpage. Ultimately, it may be by live streaming these proceedings, many more members of the public will be able to view them than would have otherwise been the case if the only way to observe them was to be here and attend in person. It is not always the case that members of the public are able to attend hearings in person, and in that respect, I thank the Council for making the Chambers the associate technology and staff available for the duration of the hearings to enable that to occur. Quite frankly, this is probably the only venue that could accommodate us and allow us to get this out to the wider public in this form. That assistance has assured that these proceedings are now available to be viewed by any member of the public, wherever they may be, at whatever time they may wish to come in and out of the proceedings, should they wish to do so. If we encounter difficulties with the live stream, and I don't expect we will, I intend to pause the proceedings until they are rectified. The technology has been thoroughly tested and I'm confident we will be able to proceed without interruption. If, however, a break in transmission does occur, I ask that members of the public who may be viewing the hearings to remain patient. Sometimes technology fails us through no fault of anybody. Rest assured, if that occurs, those assisting the inquiry will be working hard to restore the stream as soon as possible, and those observing the hearings will not miss anything, as I will not proceed until the stream is restored. The live stream is not to be recorded, whether by image or sound, and no still images are to be taken. The same restriction applies to those who may be present in the hearing room. There is to be no recording of these proceedings, whether by audio recording device or video, and there are no photographs to be taken. The proceedings are being transcribed, and a transcript will be made available on the inquiry's website once it's available. Standard sitting times will be from 10 a.m. until 1 p.m. and 2 p.m. until 4 p.m. There will be a mid-morning break at about 11:30 for 15 to 20 minutes. During each of those breaks, and of course overnight, the live stream will be paused. The standard times are subject to change at my discretion to ensure the efficient conduct of the proceedings. Vast experience in the conduct of hearings tells one that sometimes times don't quite line up and witnesses can't quite be there at the appointed time. We'll manage those things to ensure, as best we can, as little disruption to people's lives who have been summoned here today. I do appreciate that answering a summons takes people out of their ordinary activities, be it work or family commitments, and we are endeavouring to minimise the inevitable disruption that will occur. In the event that I am satisfied that some part of the public hearing should be conducted in private session, consistent with my remarks earlier, the live stream will be paused and no transcript of that part of the proceedings will be made available. These hearings are currently scheduled to conclude on 14 April 2022. In the event that the evidence is not complete by that time, I intend to list the hearings for such further days that are required to complete the evidence at the first available opportunity after 14 April. As set out in the practice direction, at the conclusion of the evidence, I propose to make directions for final written submissions, unless that is by those who are most directly affected by the terms of reference or any of the evidence given in these proceedings. Unless I am satisfied that good reason exists, I do not propose to permit oral submissions following the conclusion of the evidence. Having made those opening remarks, I now invite Mr. Parrish to make his opening address.
Thank you, Commissioner. As you have just set out, this is an inquiry into the Wingecarribee Shire Council, and in particular, the conduct of its governing body. The Shire covers approximately 2,700 square kilometres and is comparable in size to urban Sydney. It comprises 4 main urban centres, Mittagong, Bowral, Mossvale and Bundanoon, smaller villages such as Robertson, Berrima and Exeter, as well as a mix of rural and semi-rural areas. And I commend to you, Commissioner, the excellent map on the Council website to fill in that extremely brief geographical survey. The traditional custodians are the Gundungurra and Tharal people. The population of the Shire is approximately 52,000 people, and the median age is 10 years higher than the state and national medians. The council itself was an amalgamation of the Mittagong, Bowral and former Wingecarribee councils in 1981. It presently employs approximately 495 full-time equivalent staff
and elects 9 councillors. It does not have wards, and the mayor is elected by the governing body with a 2-year tenure. And I will take you to the 2 mayors who were elected during the 2016-2020 term shortly. This council, like all councils in New South Wales, has 121 regulatory functions. It has 309 separate regulatory roles that emanate from 67 state acts, administered by 31 state agencies. You can find that Commissioner in the IPART report into local government compliance and enforcement. The primary state act regulating the council, and I interpolate to note that, Commissioner, you forgot the standard admonition about turning one's phone off prior to commencement.
Did Mr. Broad, failing to do so, has reminded me that I should have said to anybody who may be here or may be coming in the future that mobiles should be switched to silent, and that having occurred once, I'm hopeful it won't happen again, although experience tells me that it's likely to happen more than it ought to.
The primary state act regulating the council is the Local Government Act 1993, and the Local Government Act 1993 is the act I'm most likely to lapse into referring to simply as the Act throughout this inquiry. That Act sets out the parameters of the role and conduct of both the governing body and the staff in some detail, and that's something I will be taking you to shortly.
Do you want me to take it up now, or are you coming?
No, I'll come to it shortly, Commissioner. The extent and sometimes the complexity of the council's roles and functions is something that should be borne in mind when the inquiry deals with the council's role as a whole, the governing body's role, and the staff and management's role. As you've set out, Commissioner, this inquiry in particular focuses on the elected body or the governing body that was elected in 2016 until their time of suspension in March 2021. The 9 councillors were elected in the local council elections held statewide on 10 September 2016. There were a total of 56 candidates over 8 groups, with 6 of those 56 candidates ungrouped. And for a tender bundle reference, that's tender bundle A, page 6. There were 36,813 enrolled voters with a turnout of 80.2%. While you have tender bundle A in front of you,
Yes.
Commissioner, I could take you to page 8.
Yes. Do you want to tender this?
I will tender it now.
Do you want to do it now or at the end?
Yeah, I'll do tender bundle A now, and I'll do tender bundle B when I come to refer to it. So
Yes.
for now, I will formally tender bundle what I have marked tender bundle
Yes.
A.
Well, that bundle of documents of 2 volumes covering 1,502 pages, is it? Is that the
That's about
accurate one?
Yes.
Will be Exhibit A. Mr. Parrish, I propose to make documentary exhibits available publicly on the website. Is there anything in Tender Bundle A that ought not be made publicly available?
Not in tender bundle A. I'll deal in due course with some possibilities in tender bundles B and C,
Yes.
but not in tender bundle A.
And I include in that private contact details.
There may be some private contact
Right.
details if that could be, if I could seek leave to perhaps
Yes, well,
deal with anything in that respect.
what I think I'll ask those assisting the inquiry to do is to review Tender Bundle A, mask private contact details, as is commonplace in inquiries of this kind. Those sorts of details are not usually splashed across the internet, and then it will be placed on the inquiry's webpage. I'll ask that to be done as promptly as it can be. Thank you.
Thank you, Commissioner. At page 8 of Tender Bundle A, we have the results of that election. The councillors elected and the governing body, the subject of this inquiry, were as follows. Mr. Duncan Gare, Independent, received 1,296 first votes. Mr. Graham McLaughlin, Labor, received 609. Mr. Graham Andrews, Independent, received 638. Mr. Gordon Markwart, Greens, received 314. Mr.
So
Larry...
these are, sorry to interrupt you, these are individual votes. They don't take account of the
No.
the group vote, though, do they?
No, that's correct.
Yes.
I'm giving you, Commissioner, the first
Thank you.
individual votes. Mr. Larry Whipper, Independent, 836 votes. Mr. Gary Turland, Independent, 287 votes. Mr. Ken Halstead, Independent, 909 votes. Mr. Ian Scandrett, Independent, 433 votes. And Mr. Peter Nelson, Independent, 37 votes. Those 9 councillors have been summoned and most have made submissions too. You will be taken to council meetings that were streamed in due course, and to assist with your identification of the relevant identities, I can commend to you page 18 of the Tender Bundle A, which has photos of the councillors in the 2016-17 report. That will somewhat help you pick out who is who in the meetings that might be addressed before you, although of course you will be hearing from these councillors in due course and will no doubt quickly become familiar with them. At the first meeting on 28 September 2016, Councillor Ken Halstead was elected Mayor and Councillor Ian Scandrett was elected his Deputy. That information is found in an electronic tender bundle of the meetings of council during the term, which I'll tender now in electronic form as Tender Bundle F.
The gap from A to F suggests that there's B to E to come.
It
Should
will.
I mark the electronic bundle Exhibit F?
You should.
Yes. All right. Exhibit F will be the electronic tender bundle of minutes of meetings of council in the period 2016 to 2021. Is that accurate, Mr. Parrish?
Yes.
Thank you.
Commissioner. Mayor Halstead and Deputy Mayor Scandrett held those offices until 26 September 2018, at which time Councillor Duncan Gare was elected Mayor and Councillor Gary Turland was elected as his Deputy. The General Manager at the time of the election was Anne Prendergast, who held the position until she resigned in July 2020. 2 other personnel matters to note at this stage in opening, Commissioner. Councillor Markwart resigned for health reasons in August 2020, and Councillors Halstead and Turland resigned at or about the time of the suspension in March 2021.
When you say at or around, do I understand that to be prior to?
I think Halstead was prior to, and Mr. Turland may have been the day after.
I see. Thank you.
So we're dealing with 6 suspended councillors out of the original 9 elected councillors. If I can just expand slightly on the procedural history that culminated in the suspension order and then the inquiry that, Commissioner, you've dealt with in some detail already. The inquiry is held pursuant to an order made by Minister Hancock on 31 August 2021 under section 438U of the Act, and it was gazetted on the 1st of September 2021. That order is at page 1 of Tender Bundle A. and I'll come back to go into some more detail about the actual terms of references shortly. The inquiry followed a set of procedures that are set out in Chapter 13 of the Local Government Act, and in particular Parts 6, 7 and 8. In respect of Part 6, a performance improvement order was issued on 8 September 2020 that under 438A of the Act, that was preceded by an intention to issue such an order on 14 August 2020. And that is at page 1 of Tender Bundle B.
You tender that now?
Yes.
Exhibit B will be a bundle of documents marked Tender Bundle B. Page 1, was it?
Yes.
Yes.
That is the letter enclosing
Yes.
the intention to issue a performance improvement order that is signed by Minister Hancock on 19 August 2021. And that was done under Chapter 13, Part 6 of the Act, which required a notice of intention to be issued before the performance improvement order was issued.
That's just that's a method of affording procedural fairness, is it not?
Right.
Yes.
And I just might take you to some of those matters now. The notice was required to, and it did, specify the terms of the proposed performance improvement order, the reasons why it is proposed, and the actions that may be taken if the order is not complied with. At page 2 of Tender Bundle B, noting correctly, as the Minister does, that these are mandatory criteria, the reasons set out proposed under section 438 capital A, subsection 3A of the Act are as follows. There are reputational and work, health and safe risks facing council as a consequence of the behaviours of some councillors. There is evidence of hostility and acrimony between councillors that, if unaddressed, is likely to lead to dysfunction. There are behaviours that indicate that some councillors may not understand their obligation under the Code of Conduct when dealing with staff of the council. And then number 4, there are behaviours that indicate some councillors may not understand their obligations under the Code of Conduct when dealing with each other. And the next proposal down under section 438 capital G was foreshadowing, in the Minister's opinion, the need for a temporary advisor with requisite professional qualifications to bring councillors together to address acrimony and hostility that is apparent, and with the requisite skills and meeting procedure required to provide advice and assistance with the conduct of the council meetings. The next mandatory matter that needed to be canvassed by this letter was the terms of the proposed performance improvement order, including the period for compliance. This is in fact found in the electronic Tender Bundle B at the back, the draft proposed orders that might not be in front of you
Oh, I see.
at the time,
Thank you.
but just until the hard copies make its way into Tender Bundle B,
It's just a draft of the
it's
order,
a
isn't it?
draft which matches with the orders that were eventually issued.
Yes.
Which is just the point I wanted to draw your attention to at this stage. There was then an invitation to make submissions to the Minister regarding the proposed performance improvement order, which was required under sections 438 capital C 3 and 4, and the Minister did so stipulating that they were to be provided no later than 7 days from the date upon which the notice was served. What the council did in respect of that draft notice, performance improvement order and the intention notice was to hold an extraordinary meeting of council on 24 August 2020 and pass resolutions. Those resolutions are found at page 11 of Tender Bundle B. The council moved and passed motions that the council acknowledges the minister's correspondence dated 19 August 2020 notifying the council of the minister's intention to issue a performance improvement order on council under section 438 of the Act. The second motion was the council advised the minister that it accepts the reasons for the order as detailed in the schedule and accepts the action required to improve performance in Schedule 2, and that it accepts the proposal for the appointment of temporary advisors under Schedule 3. The third motion passed was that the council provide all necessary assistance to the proposed temporary advisor when appointed, including access to relevant documents and video files for the term of the council. 4, the motion passed was that the Wingecarribee Shire Council agrees with the intent of the proposed performance improvement order to be issued under the relevant sections, with particular emphasis being placed upon A, the legislative responsibilities, and finally that the minister ensure that any investigation undertaken by any representative of her be comprehensive and include both elective representatives of the Shire and members of staff and council.
Can I just interrupt you? Point 5 of that motion, that the minister ensure that any investigation undertaken, is that what the minister was proposing, the draft performance improvement order, that there be an investigation, or was it something else at that stage?
No, Commissioner, as you can see, going back to the initial letter, what was called for was written submissions in respect of the proposed performance order to be provided within 7 days. That will be the subject of some examination and exploration.
I just wanted to, I'm not missing anything.
But no, you're not missing anything.
Thank you.
And the response, both substantively and the form of the response being the passing of a resolution at council, is something that I will be seeking to make submissions to you on due course, and it will be explored perhaps whether this response was possibly inadequate and indicative of a lack of understanding of the governing body's obligations. And you've already dealt with in some detail the 9 March 2021 seeking of the extension of the time for the suspension and a meeting with the minister, which also may be indicative of a lack of appreciation of what was really being sought by the minister. I understand. Thank you. Sorry to interrupt.
But no, at the very least, it's something that will be explored with the relevant persons. And so it was that the performance improvement order was issued on 8th September 2020, and that is found at page 835 of Tender Bundle B. You've dealt with it in brief compass, Commissioner, but I might just go through it again because it bears not only on the terms of reference, obviously, but given the public nature of this inquiry, it's also important for members of the public to understand the process that was undertaken.
Indeed.
So that commences at 835 of Tender Bundle B, and it by and large reflects the proposed reasons for order that were addressed in the intention letter set out in Schedule 1 and Schedule 3 on page 837 deals with the appointment of temporary advisors. Those advisors were Mr. Norm Turkington, appointed as a temporary advisor, and Mr. Ian Reynolds, also appointed as a temporary advisor, both under section 438G of the Local Government Act. You've dealt in some detail, Commissioner, with the events surrounding 9 March 2021. That was followed by the suspension by Minister Hancock of the Council on 12 March 2021.
Just so I have a reference to the 9 March response to the notice of intention to suspend, is that material contained in what is now Exhibit B?
Yes, it is, but I'll find you the reference in due course.
Thank you,
Minister. The next document I wanted to take you to, Commissioner, was at page 838 of Tender Bundle B. Back up for the moment.
Yes.
That is the 12 March order under section 438I of the Local Government Act, suspending the council and appointing Mr. Viv May, BSM, as the interim administrator of the council for the period during which the council is suspended. It's probably an appropriate time to note that there is reference at time to council capital C, which is really referring to the governing body, and the phrase elected body or elected council is also used from time to time.
Yeah.
I tend to prefer governing body, and we'll try and use that as consistently as possible, being the phraseology used in the Act.
Yes.
Although from time to time we may trespass into other acts, such as the Environmental Planning and Assessment Act, which uses different nomenclature again.
Quite. So just for ease of following, do you propose to refer to council in general terms as the organisation, and as distinct from that, the governing body as the elected representatives? Is that how you're going to proceed?
Quite.
Thank you.
And I should also say, distinguish the staff as either the executive, the senior management, or the staff and management.
Yes. Sometimes distinctions of that kind are not easy to discern from the Act.
No, and that's something I'm going to come to in a second, the use of some of the phraseology under the Act as distinct for what is colloquially used. Following the appointment of Mr. Viv May as the administrator under section 438M, Mr. May provided reports to Minister Hancock, who extended the suspension for a further 3 months twice until the orders made for the inquiry on 31 August 2021, gazetting it the next day, and also including the terms of reference, which I've already taken you to at the commencement of Tender Bundle A. The powers you have been given, Commissioner, to conduct this inquiry under section 43U come from Division 1, Part 2 of the Royal Commissioners Act 1923. You have the powers generally of a Royal Commissioner, but none of the special powers. You do not have powers to make findings of corrupt or criminal conduct, although you do have a power under section 12 capital A of that Act to communicate any information to law enforcement agencies, including the ICAC, if material relates to a breach of law or of a state or Commonwealth Act. that's something I will address you on if I need to and make recommendations for. It's something that's already come up in one context, but I pause to note for now that that is a relevant and necessary constraint on your powers, and obviously a relevant and necessary constraint on this inquiry. There are some guideline sections and documents that I ought to draw your attention to at this time, and in particular the way some of the documents which govern the conduct of the governing body interact with sections of the Local Government Act. I understand, Commissioner, you have a copy of the Act
Yes.
with you.
Yes.
Can I start at section 8, capital A of the Act? This was an amendment to the Local Government Act shortly before the election of the governing body in about, I think, August 2016.
There were quite a number of amendments at about that time.
It did, right? and I'll deal with some of them as we go throughout the morning, Commissioner. It sets out at 8A guiding principles for councils, small c. The following general principles apply to the exercise of functions by council. I won't read out all of them. They go from A to I, but I should note the requirement for councils to provide strong and effective representation, leadership, planning and decision making, to plan strategically using the integrated planning and reporting framework for the provision of effective and efficient services and regulation to meet diverse needs of a local community, and to apply the integrated planning and reporting framework in carrying out their functions so as to achieve desired outcomes and continuous improvements. Councils should work cooperatively with other councils and the state government to achieve desired outcomes for the local community, and it should work with others to secure appropriate services for local community needs. Council should act fairly, ethically and without bias in the interests of the local community, and should be responsible employers and provide a consultative and supportive working environment for council. There is also in subsection 2 the following principles in respect of decision making by councils. Councils should recognise diverse local community needs and interests. It should consider social justice principles. It should consider the long-term and cumulative effects of action on future generations. It should consider principles of ecologically sustainable development, and the decision making should be transparent, and decision makers are to be accountable for decisions and omissions. I'll skip over 8 capital B for the moment and go to 8 capital C. That is the integrated planning and reporting principles that apply to councils and which are referred to in some of the functions and principles set out in 8 capital A. The following principles for strategic planning apply to the development of the integrated planning and reporting framework. Council should identify and prioritise key local community needs and aspirations and consider regional priorities. Council should identify strategic goals to meet those needs and aspirations, and develop activities and prioritise actions to work towards those strategic goals. Council should ensure that the strategic goals and activities to work towards them may be achieved within the council resources, and should regularly review and evaluate progress towards achieving those goals. Council should maintain an integrated approach to planning, delivering and monitoring, as well as reporting on these strategic goals. and councils should collaborate with others to maximise the achievement of these. Council should manage risks in local community or area, or to the council effectively and proactively, and council should make appropriate evidence-based adaptations to meet changing needs and circumstances. I'm going to deal a little bit more with that shortly when we begin to talk about the demarcation between operational and strategic, Commissioner. While I am in the low numbers of the Local Government Act, I might just pause to point out
We're not going to the 700s?
We may do. We may touch briefly, though, upon section 10.
Yes.
Which, while not directly relevant to the matters I'm talking about right now, I should note the powers set out in subsection 2, where a person, whether a councillor or other person, is not entitled to be present at a meeting of the council or of such a committee if expelled from the meeting, either by resolution of the meeting or by the person presiding at the meeting if the council has by resolution authorised the person presiding to exercise the power of expulsion. And now turning to subsection 3, a person may be expelled from a meeting only on the grounds specified in or in the circumstances prescribed by regulations. I just raise that now because conduct of meetings will be something which is not only the subject, I anticipate, of community oral evidence, but also something that will need to be explored with the councillors themselves. Chapter 9 of the Local Government Act, Part 2 in particular, then sets out the roles of the governing body, the councillors and the general manager. And if I can take you then to section 223 of the Act.
Yes.
This is now dealing with the role of the governing body. Subsection 1 states that the role of the governing body is as follows: to direct and control the affairs of the council in accordance with this Act, to provide effective civic leadership in the local community, to ensure as far as possible the financial sustainability of the council, to ensure as far as possible that the council acts within the principles set out in Chapter 3 and the plans, programs, strategies and policies of the council, to develop and endorse community strategic plans, delivery programs and other strategic plans, programs, strategies and policies of the council, to determine and adopt rating and revenue policy as well as operational plans that support the optimal allocation of resources, and to implement strategic plans, including the community strategic plan of the council and for the benefit of the local area, to keep under review the performance of the council, including service delivery, and to make decisions necessary for the proper exercise of the regulatory functions, to determine the process for appointment of the general manager and to monitor that person's performance, to determine senior staff positions within the organisational structure of the council, and to consult regularly with community organisations and other stakeholders and keep them informed of the council's decisions and activities, and finally to be responsible for ensuring that the council acts honestly, efficiently and appropriately. The governing body, this is subsection 2, is to consult with the general manager in directing and controlling the affairs of the council. And that phrase, direct and control, is something that I'll come back to in a moment, Commissioner. Section 232 deals with the role of councillors in their individual capacity, as distinct from as the governing body. Subsection 1 states that they are to be an active and contributing member of the governing body, to make considerate and well-informed decisions as a member of the governing body, to participate in the development of the integrated planning and reporting framework, to represent the collective interests of residents, ratepayers and the local community to facilitate communication between the local community and the governing body, to uphold and represent accurately the policies and decisions of the governing body, and to make all reasonable efforts to acquire and maintain skills necessary to perform the role of councillor. And then subsection 2, a councillor is accountable to the local community for the performance of the council.
Can I just ask you about 232 subsection 1F?
Sure.
To uphold and represent accurately the policies and decisions of the governing body.
Yes.
How does that, how do you say that works if a councillor disagrees with the decision taken by the majority?
Well, a decision taken by the majority is a decision of the council.
Yes.
And therefore I say that it is a statutory obligation to uphold and represent accurately that decision.
Yes.
Even if one is a member of the minority,
Yes.
even if one does not agree with the decision passed, there is a statutory obligation under 232(1)(f) to uphold and represent accurately the decision of the governing body.
Would it prevent such a councillor maintaining their opposition to the path taken by that particular resolution?
Commissioner, my submission in that respect, I anticipate, will be that there are some shades of grey
Yes.
there, and one may have certain views, and perhaps one may express certain views. Whether that transgresses into failing to uphold and represent accurately that decision may be something that is in a grey area and maybe something that needs to be explored.
I mean, you say, as I understand it, uphold and represent accurately are fairly clear terms.
Yes.
Whether that can be done consistently with the statutory obligation in a way whilst maintaining overall opposition to a course that's taken may depend on how it's done.
Right.
Do I understand you correctly?
Quite.
Thank you. Sorry to interrupt.
And of course, noting the terms of inquiry, which we'll come to soon, it's as much a question of what the council has understood that to mean, as it is perhaps coming to a final view on what the outer boundaries of that is.
I understand.
Can I briefly turn to section 335, which is in chapter 11?
I'm sorry, just before you leave 232, I recollect that was part of the 2016 amendments. Is that right?
I think it was.
Yes, you can come back to it if you know.
Yeah, if you wouldn't mind, I'll come back to that,
Yes, of
Councillor. I
course.
think you're right.
I'm sorry, where were you going next?
I was going to say, one thing I might just refer to you also at this point in time is, while we have it in front of us, the next subsection down, subsection G, states the necessity to make all reasonable efforts to acquire and maintain the skills necessary to perform the role of councillor. I
Yes.
just flag that for the moment. It's something that will be explored. The councillors did, it appears, have induction sessions upon becoming councillors. So some of the councillors had previously been elected. And I'm not suggesting in opening that they did not do it, but it is something that will be explored
Thank you.
in examination. And I only raise it now is because it is a section which perhaps scoots under the more substantive sections. It is nonetheless important and is a statutory obligations on the councillors. I was going to take you to 335 next, Commissioner, which is in chapter 11 of the Act.
Yes, I have that.
That addresses the functions of the General Manager of Council, and it states that the General Manager of Council has the following functions: to conduct day-to-day management of the Council in accordance with the strategic plans, programs, strategies and policy of the Council, to implement without undue delay lawful decisions of the Council, to advise the Mayor and the governing body on the development and implementation of the strategic plans, programs, strategies and policies of the Council, to advise the Mayor and the governing body on the appropriate form of community consultation on the strategic plans, programs, strategies and policies of the Council, and other matters related to the council, and to prepare in consultation with the Mayor, the governing body and the council's community strategic plan, community engagement strategies, resourcing strategy, delivery programs and operational plan and annual reports, to ensure that the mayors are given and other councillors are given accurate and timely information and advice and the administrative and professional support necessary to effectively discharge their functions, to exercise any of the functions that the council delegates to the general manager, to appoint staff in accordance with the organisation structure determined under this chapter and the resources approved by council, to direct and dismiss staff, to implement the workforce management strategy, and then any other functions. Now, the reason I've done it in the order that I've done it there, Commissioner, is because there's some lack of clarity, at least in the mind of council assisting, as to the use of some of the terms that are used. For instance, operational and strategic. Those terms are not terms necessarily used in the Act in the way which they are used in some of the materials. The way that these sections interact in my submission, it appears that it is the role of the governing body to set the planning and strategic direction of the of the council, and it is the role of the staff management and the general manager to implement it. And that's something I'll come back to shortly in respect of the terms of reference. But for now, the next thing I want to draw your attention to is the conduct regulations and documents which regulate and govern the behaviour of both the elected body, the governing body, I should say, and at least senior staff and other staff as well. In that respect, I anticipate we will deal extensively with the codes of conduct and the codes of meeting practice. There are various iterations of those which are intended bundle A, and which I don't intend to take you to right now.
Okay.
Section 440 of the Act requires that the council must adopt a code of conduct that applies to councillors, members of staff of councils and delegates.
Yes, I have them.
Further through that, at 440 capital F, is a section which deals with misconduct. I'll just pull that up.
Yes.
Misconduct of a councillor means any of the following: a contravention by the councillor of this Act or regulations, a failure by the councillor to comply with the applicable requirement of a code of conduct, a failure by a councillor to comply with an order issued by the departmental chief executive under this section, an act of disorder committed by the councillor at a meeting of the council or a committee of the council, and an act and omission of the councillor intended by the councillor to prevent the proper or effective functioning of the council or a committee of the council. So we have there by 440 capital F1B at least a statutory recognition that a failure to comply with a code of conduct is an act of misconduct under the Act. Section 360, going backwards, states that the regulations may prescribe acts of disorder for meetings or committees. I take that to mean that once a regulation sets those matters out, it is then incorporated into 1A, thereby meaning that there are both codes of conduct which address norms of behaviour, as well as statutory obligations in the regulations, which also deal with norms of behaviour.
Sorry, just stepping back, which part of 360 did you
Pardon me.
wish to take me to? So
Pardon me. 360 prescribes the model code of conduct for the
Yes.
conduct of meetings.
yes, that requires the council to adopt
Yes.
at least the model code, and they can have more, but it can't be inconsistent with the model code.
Yep.
Yes.
It may contain both mandatory and non-mandatory provisions, and must not later than 12 months after the ordinary election adopt that code.
Yes.
Must not contain provisions inconsistent with the mandatory provisions, and a council and a committee of the council, of which all the meeting members are councillors, must conduct its meetings in accordance with the code of meeting practice.
Yes, I see.
So there we go. We've got another
Yes.
statutory obligation
So
imposed.
your submission is 360 subsection 5 would then fit into section 440 capital F 1A. If there was a contravention of the code of meeting practice, it may constitute misconduct as defined, being a contravention of the Act.
That's
Is that how you put it?
Yes, Commissioner.
Thank you.
I'm unsure whether you've got the regulations in front of you.
I can pull them up.
Yeah, I don't have them in hard copy either.
That's all right. Just give me one moment. They were almost entirely replaced.
Yes.
So it'll be the 2015. Is it the 2015 regulation?
I'm working off the 2021,
I see.
but I'll draw it back to the 2021, the ones
Okay.
that were in substantially the same form at
Thank
the
you.
time.
All right. So I can look at the current
You
regulation.
can look at the current regulations for the moment.
Okay. Thank you.
And a couple of regulations.
The local government general regulation, is that the
Yes,
one you
that's
want me
the
to
one.
have? Yes, I have that, thank you.
2021.
Yes. Which clause would you like?
Okay, can I start with 232
Yes.
of the regulations? Which states that the model code is published in the Gazette in 29 October 2021, prescribed for the purposes of the Act, and I'll draw you back and cross-reference to the relevant one at the time in due course.
Yes.
I just want to go through the architecture of the regulations at the moment.
Yes.
233 sets out the ability of a chairperson to expel a councillor. It says that the chairperson may require a councillor to apologise without reservation for an act of disorder referred to in section 182. I'll bring you to that in a second, Commissioner. To withdraw a motion or an amendment referred to in section 182C, and where appropriate, apologise without reservation. C, retract and apologise without reservation for any statement that constitutes an act of disorder referred to in 182D or E. 2, a councillor may, as provided by 10A, 2A or B of the Act, which is what I took you to before, be expelled from a meeting of a council for having failed to comply with a requirement under subsection 1. The expulsion of a councillor from the meeting for that reason does not prevent any other action being taken against the councillor for the act of disorder concerned. 3, a person other than a councillor may, as provided by 10(2)A or B of the Act, be expelled from a meeting of a council for having engaged in disorderly conduct. That puts some meat on the bones of section 10A2, and in my submission is also consonant with the model code of meeting practice. That's probably the appropriate time then to take you to regulation 182 in the same regulation, which sets out the relevant acts of disorder as facilitated by section 490 capital A of the Act.
I have that.
Councillor commits an act of disorder if the councillor at a meeting of a council or a committee of a council contravenes this act, this regulation, or any provision of the code of meeting practice adopted by the council under section 363 of the Act, including any provisions incorporated in the adopted code that are prescribed by this regulation as mandatory provisions of the model code of meeting practice, or assaults or threatens to assault another councillor or person present at the meeting, or moves or attempts to move a motion or an amendment that has an unlawful purpose, or that deals with a matter that is outside the jurisdiction of the council or committee, or address or attempts to address the council or committee on such a motion, amendment or matter. Now subsection D, insults, makes unfavourable personal remarks about or imputes improper motives to any other councillor or member of staff or delegate of council, or says anything that is inconsistent with maintaining order at the meeting or is likely to bring the council or committee into contempt. And a couple of reasons I wanted to draw this to your attention at this stage, Commissioner. It appears to interact with the statutory prescriptions in respect of misconduct in section 440 capital F. It appears to tie in with the code of meeting practice adopted by the council under section 363, and it then adds to those other matters several, I would submit, rather obvious norms of behaviour that ought to take place at councils. So there are multiple avenues under the statute and its regulations regulating the behaviour of councillors. And that's something that will form part of your inquiry, in which there'll be oral questioning on. The other point to note is that this interaction of the various regulations, statutes and sections is not necessarily straightforward. There is some complexity to the way they interact, and of course that should be borne in mind when both oral questioning is taking place and final submissions are made to you, Commissioner. So with that short overview of the Act and its regulation, I might now turn to the terms of the inquiry itself. The scope of the terms of reference were made under sections 43U, W and Y by Minister Hancock, and I've referred to them a few times. They're at the first 2 pages of Tender Bundle A. You have given some opening remarks, Commissioner, about how you see those terms to define the scope of your role. I shall now both give you my submission on what I say that means and also make a few further comments. The first term is whether members of Council's governing body fully understood their roles and responsibilities and have adequately, reasonably and appropriately carried out their roles and responsibilities during the current term of Council. In my submission, that has 2 parts. Firstly, to determine whether the 9 councillors fully understood their roles and responsibilities, and secondly, to inquire whether they fulfilled those roles during the 2016 term. The first part has an element of subjectivity that will need to be explored with each of the individual councillors, and will also be informed by the training and induction procedures that took place at the time and manifest themselves most obviously in the council meetings themselves. The second part, that is, did they fulfil those obligations, roles and responsibilities, is a wider question that will be informed by the evidence received, not only from council records and submissions, but the community themselves, and how the councillors projected their roles and responsibilities and the perception that was received in the wider community. Of course, the evidence of councillors will also be relevant to the second part of that wider question as well. Term of reference 2 states whether during the current term of council there has been improper interference by the elected body of council, pausing there, I think we both take that to mean the governing body, or by individual councillors in operational matters with particular reference to staffing and planning functions. In my submission, it is necessary to understand this question within the context of the legislation I've just taken you to. You may hear through the course of the inquiry this distinction between operational and strategic. This gives effect to the fact that the role of the elected councillors is to, in my submission, set the strategic direction of the council, and it is the management and the staff who are responsible for the operational day-to-day administration of the council. I should note that this operational strategic distinction is therefore more colloquial than technical, because the Act does not demarcate the roles in those words. I've already taken you to section 223 of the Act, which deals with the role of the governing body, that is the councillors as a body politic, and that says that their role is to direct and control. I take that to be synonymous with strategic as distinct from operational, but I will also be exploring what the councillors understood that to mean. Section 232, which deals with individual council roles, is more high level and aspirational than 223. But you can take it that the role set out in 232 cannot rise above the 223 roles in the body that they are part of, nor intrude onto the functions of the general manager, which is the reason I took you to section 335 at this time. Section 335 sets out the functions of the general manager, and the first of which, I note, is the conduct, the day-to-day management of the council in accordance with the strategic plans, programs, policies of the council, and the second is the implementation of the decisions of the council. Can I pause there briefly to take you to page 446 of Tender Bundle A?
446.
446.
I have 446.
Pardon me, can I take you to 461?
461. Yes, I have that.
That's what is referred to from time to time as the hourglass model, which sets out the council's structure.
This is a page from the councillor handbook.
That's correct.
Yeah.
Now, that document, that hourglass, and how both that sits with 223, 232 and 335 of the Act, and what the council has understood that interaction to be, whether there was any distinction, is something I'll explore in due course. But what you can see from both phraseology such as operational versus strategic, this implementation of frameworks with reporting to council on activities and outcomes, as well as the phraseology in the first two subsections of section 335, is that there is, I wouldn't put it high as confusion, there is some areas in which there are different words used to mean the same thing, which don't necessarily match up with the word used in the Act. My submission, I anticipate, however, will be that while the Act doesn't make a clear demarcation between the words operational versus strategic, it is clear that there is a distinction between direct and control, which is for the governing body, and implement and manage, which is for the general manager and staff. And my submission will be that when one goes back to those guiding principles at capital A and capital C, section 8, which we started with, it's quite clear in my submission that what 8C does is flesh out both 8A subsection 1 capitals subsections C and D, and also makes it clear when one then reads 232, 223 and 335 that the governing body's role is to come up with, identify, priority, and then set strategic goals as part of the integrated planning and reporting framework, and that it is the staff and the general manager's role to implement that.
Yes, just on 335. I understand what you say, that the Act doesn't use these words. One has to get there through a combination of an analysis of various sections to get to what is ultimately represented in the diagram in the councillor handbook. Do you also, have you got 335?
Yes, Commissioner.
Do you also say that subsection I is also relevant to that demarcation, that it is solely within the purview of the general manager to direct and dismiss staff?
Yes.
Do you read direct in that context to direct in the performance of their day-to-day role?
Yes.
And the only staff member that's actually engaged by the governing body is the general manager, him or herself, correct?
Yes. And conveniently touching on my next point, and I thank you for the segue, Commissioner, is that their roles don't interact or overlap in that respect, that of the governing body and the general manager. If there is a role set out for the general manager or a function at 335, that does not mean that there is some grey area which the governing body may involve themselves with.
Yes.
It is the intention, I say, of the Act that there is a bright line between those activities.
Yes, perhaps where there may be confusion is not the right word, but where issues might arise is what is within each of those categories rather than that they exist.
Right.
Yes. I see the time. Is that a convenient moment to have the morning adjournment, or?
Thank you, Commissioner.
Yes, all right, we'll adjourn until 10 to 12. Yes, thank you, Mr. Parrish.
Thank you, Commissioner. I was just dealing before the break with the distinction between operational and strategic and the slightly different wording and slightly different conceptual use of the words in the Act itself. But just to tie up that proposition that the roles of the General Manager and ergo the staff below her and the governing body, on the other hand, are distinct ones that do not overlap. Can I just take you to page 1280 of Tender Bundle A, Volume 2?
Volume 2, yes.
This is page 1280 from a meetings practice note, August 2009, which has some use as an aid and which also there hasn't been significant changes of the Act since then. At 1280, there is a reference to clause 8.1.2, and what should be the relationship between councillors and councillors' staff. And it says, the Act makes the General Manager responsible for the efficient and effective operation of the Council's organisation and for implementing decisions of the Council, and then refers to the section we've been talking about in the Act, section 335. It then says, the General Manager, therefore, is in charge of Council's management. Councillors are required, as a group, to direct and control the Council's affairs. We've seen that word come up a few times this morning.
Yes.
Allocate resources and determine and review the Council's policy and performance. Section 232 of the Act. Councillors should not involve themselves in the day-to-day administration of the Council. This is the responsibility of the General Manager. So I just wanted to take your attention to that to close the loop on my analysis of the various sections of the Act in regard to both the distinction between direct and control on the one hand and day-to-day management and administration on the other, and also the use of this term operational versus strategic.
Thank you.
While we're here, we should also note that it says that councillors and staff have a responsibility to behave professionally and maintain constructive working associations. This is based on the principle that all public officials have a duty to act with integrity, honesty, impartiality and in the public interest, and that the council laws must not make personal attacks upon staff at meetings. If a councillor has a complaint about a member of staff, that complaint should be addressed in writing to the General Manager. If the complaint is about the General Manager, that should be addressed in writing to the Mayor. And then it deals with Section 9 of the Model Code. We'll come to a more up-to-date version of that in due course, given this is something from 2009, but makes the very obvious point that councillors should familiarise themselves with those provisions and use them as a guide to their conduct. Can I now take you to examples of the meeting code of conduct and the code of conduct? It's something I don't want to spend a lot of time on right now, but I should both flag up what they are,
Yes.
and deal with at least a few things that may be of some relevance. Can I start with an example of the Code of Meeting Practice, which is at same volume 1037?
Yes.
Can you just flag that up for now, Commissioner, as something? And I just wanted to draw your attention to one relevant part of it. If I can take you to 1052, describing the chairperson, cross-referencing to the Act, that the Mayor, or at the request of or in the absence of the Mayor, the Deputy Mayor, if any, presides at the meeting. That's 7.1. If the Mayor and the Deputy Mayor are absent, a councillor elected to the chair may chair the meeting by councillors present. Then there's the reference to the election, and just down the bottom there, 7.9, chairperson to have precedence. When a chairperson rises or speaks during a meeting of the council, any councillor then speaking or seeking to speak must cease speaking, and if standing, immediately resume their seat, and every councillor present must be silent to enable the chairperson to be heard without interruption. And that's something that may arise in the examination of councillors in respect to some conduct in meetings, which it appears, I may say in opening, at the very least failed to comply with that aspect of the code. And as I've already taken you to the way that the code interacts with the Act, the roles and responsibilities in respect of the code are also statutory obligations under the Act. and I apologise in advance, I'm going to jump between volumes 1 and 2 of Tender Bundle A for a second.
Yes. I have volume 1.
Can I take you to page 740
Yes.
and just ask you to flag up an example of the Code of Conduct?
Yes.
There were multiple iterations of this document over the term, none of which contained significant differences, but it's something I'll have to deal with in due course.
Yes.
Commissioner, there are slight differences in various versions of this document. Things to note at the moment are effectively the table of contents and the parts of the Code of Conduct. There are general conduct obligations. There are specific provisions in respect of pecuniary interests, specific provisions in respect of non-pecuniary interests, personal benefit. There is another section in there in Part 7 about the relationship between council officials, access to information and council resources, and the vitality of maintaining the integrity of this code. So I just wanted to flag that up for now.
Sorry, Mr. Parrish, I've done my usual trick and spilt the water. Just bear with me just a moment.
My hard work down the drain, Commissioner.
Wouldn't be a hearing without me doing this.
No. Well, that's probably a convenient place for me to leave the Code of Conduct for now.
Yes. You continue.
But I just wanted to bring it back to Tender Bundle B, page 1280, that I dealt with a second ago.
Yes.
This framework of improper interference, which comes through in terms of reference to, there is a statutory delineation of roles. There are multiple explanations of that delineation in the documents I've just taken you to, and it is something which will be explored in due course with both staff members and councillors in respect of term of reference 2.
Yes.
Term of reference 3 states whether members of council's governing body have been and will continue to be in a position to direct and control the affairs of council in accordance with the Local Government Act 1993 and to otherwise fulfil its statutory obligations. Here we see the use of that phrase, direct and control, Commissioner. This aspect of the terms has a past tense and a future tense component to it. The past tense of it overlaps in my submission with the second limb of the first term, but this term should be read as a way to identify the position of the governing body to direct and control in the past and to therefore inquire whether there are any problems, i.e. if you determine that there were such problems, whether they can be or have been fixed. We need to know the former to be able to inquire and determine the latter. I take this term of reference, especially in the future tense, to pay attention to the governing body as a whole. It is not constructive, or in my view, within the terms of reference, to pick out individual councillors and to make findings or determinations that place specific weight on a positive or negative role as a whole. There is no power that I can ascertain that would allow the minister to dismiss or suspend a single councillor, nor is your recommendation sought on that in this inquiry, nor do I say that you would have any such power to do so. What, in my submission, you need to focus on within this term, Commissioner, is whether the 6 councillors as a whole are in a position going forward to direct and control and to otherwise fulfil their statutory obligations under 8 capital A section 223 for the balance of this term. Does the Commissioner have any questions on that in particular? Because I might move to term 4 now, unless you do.
No, I understand what you put. Do you say that 3 should be, that when construing term of reference 3, it also sits in distinction to term of reference 2 that points to individual councillors?
Yes.
Yes.
Yes, quite. There is a quite distinct use of terms between individual councillors in 2 and 3, and of course what is being asked in term 3 is whether the governing body will continue to be in a position to direct and control the affairs.
I mean, it has to be understood in the context of what this inquiry is and the legislation in which it is established.
Yes.
I understand the import of your submission about the minister seemingly lacking power to take any particular action against any particular individual councillors. That seems to be a power that rests with someone else, as I read the Act, but I'd be interested to hear any contrary view about that, should there be one.
Yes. That's not to say that the conduct of individual councillors might not be important for the factual matrix that we have to undertake, nor as a way of explaining matters that may occur. That is a wholly different issue as to whether term of reference 3 is answered in a certain way.
Yes, your point is there's not much point in me saying 1, 2 can, 2, 3 can't, 1 can. That doesn't aid the minister in her consideration of what to do going forward. To drill it down to that level.
Yes.
Is that how you put it?
Yes.
Thank you. I understand.
And in what is the autumnal wonderland of this?
Sorry to cut you off. When I say understand, I understand the submission. I haven't.
Yes.
Couldn't close my mind to the issue, but I understand what you put.
Yeah, quite. I was going to embark on a tortured analogy there, councillor, which I might therefore skip. But to cut short the analogy, we're not looking in term 3 to identify bad apples. We are looking at the whole tree, and whether in the factual matrix certain behaviour might come up, that's one thing, but it's not the scope of term 3 to identify or make recommendations about individuals.
Thank you.
Term 4 states that any other matter that warrants inquiry, particularly those that may impact on the effective administration of council's functions and responsibilities, or the community's confidence in the council to be able to do so. That is something that has been addressed by you, Commissioner, and what you say that means and how you read it. I will just add briefly in the negative what this inquiry therefore is not about.
Just before you do that, do you have a different? Do you advance a different approach to term of reference 4 than the preliminary view I expressed in my remarks?
No. Term 4 is obviously broader than the previous 3, but it does, of course, have to be read in the context of the other 3 terms, the powers that you have, the purpose of this inquiry. But in any event, to note that the term states that it is to focus particularly those that may impact on the effective administration of council's functions and responsibilities, or the community's confidence in the council being able to do so. I say that is consonant with the previous 3 terms, and when the specific informs the general, it's quite clear that what term 4 is asking is to deal with any other matters which may arise out of the previous 3 terms, and it should be read in that context.
Thank you.
Although it does allow the inquiry to have some flexibility and move wider than the other 3 terms, it still must be informed by both councillor conduct and the roles within this term of the council.
Do you wish to be heard against the proposition that what term of reference 4 doesn't require me to do is to go on a search for things that might fall within its terms? That is,
Right.
it falls to be considered as issues arise in the consideration of terms of reference 1, 2 and 3?
Yes. I wouldn't want to be heard against that.
Thank you.
But in that context, both to set out the parameters of what my closing submissions will be, Councillor and also Commissioner, and also to articulate for members of the public who might be listening to this inquiry, I'm just going to take a second to address what this inquiry is not about in my submission. This inquiry will not be addressing, certainly from my side as council assisting, the merits of any specific planning decisions. That's something you referred to. That is something which I embrace as well. We will not be relitigating approved or rejected DAs. As I've already said, this inquiry does not have the power to address general allegations of corrupt conduct, and I have already set out the powers you do have to refer them to the appropriate law enforcement body should information come to light which you deem it fit to refer to them. Likewise, other non-planning decisions made by council will not be subject to a merits review. It is not our job to second guess each and every one of the council's decisions. Notwithstanding, they have been brought to our attention, some in the submissions, and it is something we'll of course consider in the wider matrix of what we are doing within terms 1 to 4.
Can I just ask you about that? The terms of reference you put don't require reconsideration of the merits of decisions. By that, do I understand you to say that they focus on processes rather than outcomes?
Yes.
But if there was something that was devoid of process and therefore which may have led to a bad outcome, do you see that as being a matter appropriately to be explored, or is it just a function of the process, again, that leads to the particular outcome, whatever that may be?
Well, it's a function of the process insofar as I may ask questions,
Yes.
especially in the first 2 weeks of, I expect members of the community, and matters may come out of that, which will bear on your ultimate determinations.
Yes.
And the example I was going to give was not so much in defective processes, but one of the abiding themes which has been raised both by Mr. Viv May, the documents I have intend to in due course take you to, is a feeling amongst the community that the council had stopped listening. Now, we have submissions which wholly focus on the merits of individual DAs, but sometimes within that process there are themes which match with our with wider pieces of evidence that we have, such as the communication between members of the public and the community, and how the community perceives and feels that communication is being provided to them. So that's the example I was going to use of a situation where individual DAs may not be relevant for their individual merits, but may fit into wider themes within this inquiry.
Yes.
And that is why it's important, of course, Commissioner, that we read and consider all of the submissions and not discard or ignore them simply because they might not necessarily immediately fall within the bounds of this inquiry. And just on that point, we've received something in excess of 120 submissions, and all of them have been and will be considered, even if they fall outside the specific terms of reference. And as I said, there will be themes which come through. Lastly, in my submission, this inquiry's aim is not to necessarily apportion blame, find scapegoats, or otherwise justify the minister's suspension. My examination of witnesses will recognise evidence of matters where there is an understanding of roles, where there is positive interaction between councillors and staff, and that may bear on matters which both evidence that the councillors were meeting their obligations, but also may point the way towards future constructive behaviours within the council. But in saying that, I do expect we may see some recurring themes from the evidence that will bear on the terms of reference that may be more negative than positive, and I'll foreshadow a few of those now because I think it's important that you, Commissioner, understand some of the issues which will come up in a recurring theme which will better help you understand the context of them when they come up. Firstly, I expect you will hear evidence of a blurring of the line between some councillors acting in their personal capacity and them acting in their capacity as councillor. There are submissions and evidence which I expect will show that there were some times where there was a blurring of this line, and that's something that I intend to explore with councillors, both in their understanding of their roles and obligations and within the wider context of how they interacted with council staff. The second theme that is likely to come up, both from the documentary evidence, the streamed meetings we will see, and from members of the public, is the behaviour of councillors in some meetings. The meetings were live streamed and are available to be viewed. I will take you to some of them in due course, Commissioner, and some will be the subject of examination. Members of the public in submissions frequently expressed concerns about the tone and behaviour of some of the councillors, and there were some particularly memorable occasions where members of the public felt that the behaviour was, to borrow a colloquialism, tone deaf. For instance, the first extraordinary general meeting after the bushfires in 2020. The third theme that I expect will recur is about the culture within the executive and the staff at the council. The interim administrator found that there were significant reputational, work and safety risks facing the council, and I expect that will be a theme that comes up both from ex-staff and some members of the community as well. Fourthly, there is a sense from some members of the community that the council was unresponsive and had stopped listening to its constituents. This was a strong theme that came through when the interim administrator was conducting his investigations, and it's a theme that comes through in some submissions from the members of the public. I can commend to you, Commissioner, some of the satisfaction surveys which were commissioned by the interim administrator. In Tender Bundle B at page 484, if I could just flag it for you at the moment.
484?
484, yeah, let's try 484.
Yes, I have that. This is the community research survey of February 2021.
This is the February 2021 one.
Yes.
There are others. It is part of the council's framework that they have to undertake these, and it's a metric by which they judge themselves, and we'll deal with that in due course.
Yes.
But the reason I take you to the 2021 one is because it does provide a useful comparison over previous years in it as well. If I can take you to page 489.
Yes.
the high-level summaries there that we have with the little pie chart, it seems to be, donut chart, has overall satisfaction of the Shire Council in the last 12 months at 65%, where it says they were at least somewhat satisfied with the performance of the council. On the right-hand side, council's communication, residents were, 68% of residents were at least somewhat satisfied with council's level of communication.
Is the word somewhat satisfied part of the scoring metric used in this?
Yes.
Oh, yes, I see it. Thank you.
25% rated the council image as good to excellent, and 55% were at least somewhat satisfied with the overall performance of councillors. And while it can sometimes be difficult to understand the results in isolation, we're assisted in that by the numbers at page 518 of this document, of this bundle.
Yes.
That gives us a benchmark index in respect to the satisfaction scores, and helpfully on the right there a variance. So as at this survey, the council were ahead of the curve, as it were, in respect of cleanliness and functionality of public toilets and community safety / crime prevention. They were within a variance in respect of reliability of town water, resource recovery centre, support for tourism, dog control, health and natural urban streams and creeks, but not rivers, and protecting heritage values and buildings. And then we slip below the curve, I should say, at health and natural urban streams, and the council is performing lower than the benchmark in respect of the balance of those issues.
Just going back earlier to page 498. At the, do you have that?
Yes.
At the top of that page, there's a series of scores.
Yes.
Do I understand those to be the scores of similar surveys in the past?
Quite, and that's why, as I foreshadowed when I first took you to this, the reason I'm showing you the 2021 version is that it quite nicely gives us an extrapolation of the previous scores.
Yes, I understand. So if we're looking at overall satisfaction, it was 77% in 2019 and 65% 2 years later.
Yes. And going even further back, we've got 85% in 2010, 81% in 2012, 82% in 2015,
Yes.
76% in 2017.
And below that, one sees the scoring system, if I can put it that way. So
Yes.
somewhat satisfied is 3 out of 5.
Yes.
Okay, thank you. I understand how that works.
And I'm drawing your attention to that partly because it integrates with the strategic documents, but also because it's part of the theme that comes up, the sense that the council was unresponsive and had stopped listening to the constituents. A theme, I should say, that comes through in the submissions. Can I also draw your attention to the Ernest Consulting Report, which is in the same volume of Tender Bundle B at page 434.
434. Yes, I have that.
This is one of the reports that was commissioned by the interim administrator, Mr. Viv May.
Yes.
part of this report interviewed staff members about the culture, which sets out on the right-hand side there themes arising from interviews with staff members. And I won't read through them all at the moment, save to note a few. And also note that these are themes which come through in some of the submissions. Interference by councillors to predetermined recommendations, especially on planning proposals. Poor or no leadership from senior staff and the elected council, which manifests in a lack of trust in their decision making and a lack of authority to make decisions. And then poor and outdated development control plans, bearing in mind that's a role of the governing body to set, amongst other things, DCPs. Inconsistency between various strategic policies of council, such as council's position to promote tourism in the contents of the LEP, that's local environmental plan, that effectively prohibits those land uses. And then there's some other operational matters which arise as well. Something which will be explored, Commissioner, is the way in which both the senior staff and executive interacted with the governing body and the effect that that had on the staff further down. And that's again a recurring theme that will come up. I also just want to flag, Commissioner, some specific events which will be relevant and which a bit of context now may improve the efficient conduct of this inquiry. You'll see references to bushfires and the bushfire response. This refers to bushfires in the Shire at the end of 2019 and the commencement of 2020. There is a good summary of the bushfire response and recovery review commissioned by the Interim Administrator, which is at Tender Bundle B, page 272.
I have that.
In those fires, 68 residences were destroyed, 18 damaged, 197 outbuildings destroyed, 69 damaged. 24% of the Shire was subject to burn scars. This is an event which had, as you would expect, an obvious effect on the community, and some people in particular were affected in severe and traumatic ways. And there were submissions made in respect of that response, and you will be hearing from witnesses who give their experience of that response. Secondly, you will see reference to the Station Street or Bowral bypass. This was a proposed bypass to the west of Bowral alongside the train line that caused, in my submission, significant animosity and tension within the community, between the community and some councillors and within the council. We will not be examining the merits of the project, which was discontinued by the Interim Administrator, but members of the community seem to feel, at least some of them, that the consultation process was unprofessional, at times obfuscatory, and closed the community. That is something I'll be examining, and how that perception came to be within some members of the community.
I'm obviously aware of that project. Is there a document that gives and you may not be able to answer this immediately, but is there or will there be in evidence a document which gives a convenient summary of what it was and what was proposed?
Yes, there will be, but I won't take it to you.
No, that's fine. That's fine. Thank you.
Next, in respect of specific matters, the Civic Centre, where we now sit. The Interim Administrator identified irregularities in the process of approving the spending and the DA process. Again, it's not within the terms of reference to inquire into the merits of this project, but it may be relevant in the context of whether the councillors and the executive properly understood their statutory obligations, and that is something which may arise in examinations. That is by no means an exhaustive list of recurring issues or specific matters, but I just wanted to draw your attention to those things which may come up within the community, staff and councillors when they're being examined. Can I just speak roughly about the timetable that we intend to canvass in the next 3 weeks? I expect I'll be calling approximately 52 witnesses at this stage. They can conveniently be broken up into 3 groups, and I'm endeavouring at this stage to call each of the 3 groups within the 3 weeks. So the first week I anticipate calling members of community organisations and members of the public who have made submissions to this inquiry. In the second week, I intend to deal with any remaining witnesses from this week and then call the current interim administrator, Mr. Viv May, a witness from the Office of Local Government, and the present General Manager, Ms. Campbell first, followed by the other present and ex-staff members who will be giving evidence. And then in the third and final week, I intend to call the councillors. I should state at this stage that our choice of witnesses, in particular for the first week, were based on the fact that we received over double the amount of submissions from members of the public than those who will actually be called as witnesses. The members of the public who will be examined were selected based on several factors, none of which were intended to exclude or diminish the submissions made by the others who have not been called. Of the members of public who made submissions and will not be called, some of them provided comprehensive and detailed submissions that stand on their own as evidence, and no further elaboration is necessary in person given the constraints we have on time. Some dealt with specific DA issues which I've previously discussed and which I've noted fall outside the terms of reference, and again, as discussed by both you and I, will be considered insofar as they draw out themes and commonalities, but I did not determine were necessary to call as witnesses for oral evidence. Another concern is the fact that some members were expressly asked not to be called as witnesses or were simply not available within the time we had. We also had some who were unable to attend for health reasons. Of the remaining, given that we are constrained by only 3 weeks of inquiry time, we have endeavoured to call witnesses who have a direct experience insofar as possible, and at times may be able to represent parts of the community or allow us, both you as the finder of fact and me as the person providing submissions, to infer that certain themes represented by this person existed in the wider community. When I've determined that a person may be called but was unavailable, we have tried our best to find someone who has a similar level of representation within the community. I anticipate at this stage that as we call the councillors in the 3rd week, I will attempt to call the 2 mayors last, as that appears to be the natural process of doing things. But again, it will be subject to availability and timing, and I state all these things to emphasise that we have not given any preference to the order of witnesses other than convenience and logical theme.
Yes, it makes sense, it seems to me, for the elected body to be called last once the body of evidence is well formed for obvious procedural reasons, but yes, I understand.
Well, I'll just extrapolate on those obvious procedural reasons. It's to ensure that any matters which arise in the first 2 weeks can be put to councillors and they can have an opportunity to fully explain it.
Yes.
And in dealing with that, I should note that the first witness will be Mr. Steve Horton. He is currently scheduled to come at 2 p.m. today, and he'll be the only witness we hear this afternoon.
Right. In terms of witnesses generally, I appreciate there's a lot of organisation that goes in the background to line up people's availabilities. But will there be a list of who is expected the following day or the following 2 days that can be made available?
We will endeavour to be providing that to be made available as soon as possible.
All right. So for those who may be interested, a list of who may be coming on Tuesday or Wednesday could be put on the website sometime this afternoon. Is that feasible?
Yes.
Yes, I think the answer to that is yes. All right, well, for those keen observers, obviously it must be understood that things change for various reasons at short notice, so they're not, it's not a guaranteed timetable, but it gives some indication of what might be happening in the days coming.
Yes, Commissioner.
Right.
Unless there's any further questions you have at this stage, that's my only.
No. Are there any other documentary tenders you wish to deal with now?
I'll formally tender Bundle C, which I think is the bundle which has not been formally tendered as yet.
Yes.
That has some confidential material I anticipate that will need to be dealt with.
Yes.
More so than the other two bundles.
All right, so Exhibit C will be a bundle of documents headed Code of Conduct Complaints, and that won't be made a public document at the moment. I can see various confidential matters in there, so that one won't be placed on the website just yet, but once if it can be put into a form that's appropriate for publication, it will be. But
yes,
can I ask that that be looked into as soon as possible, and I'd be kept updated as to the status of whether that will become a public document?
Yes, Commissioner.
I have Exhibit F for the D&E to be tendered.
Not now,
All right.
but they will be in due course.
Okay. Mr. Riley, I perhaps cut you off earlier. I understand your application was to seek leave to represent what during the course of evidence, or more generally?
Commissioner, given the uncertainty about which witnesses I'll be appearing for, I thought I should seek leave to appear individually as those witnesses were called.
Yes, that's fine. The reason why I'm asking was if you were seeking leave to appear more generally in the inquiry, I was going to deal with that now, and then if I granted that leave, ask you whether you had anything you wanted to put to me now. But as I understand,
I would seek that leave, Commissioner, but I won't be here every day.
Yes.
If that's possible, I would seek that leave.
yes, all right. Well, you have leave to appear for whichever witnesses may deem fit to instruct you. I'll leave it to you to manage that in the usual course of your obligations. Ordinarily, that wouldn't necessarily come with an opportunity to be heard at the moment, but do you seek to be heard at the moment?
Seek to be heard at the moment.
All right,
thank you.
All right. If there's nothing further for the moment, I'll adjourn until the first witness at 2 p.m. Thank you. We ready to resume, Mr. Parrish? Before you do, there's a matter that I addressed in my opening this morning which I need to return to over the lunch and adjournment. Some contact that has occurred with those assisting the inquiry was brought to my attention, and I want to address it in more fulsome terms than I did this morning, and that is the direction I've made about who can be present in the hearing room. When the hearings were announced, I made it clear that my intention was to limit the categories of persons who may be in the hearing room in order to give priority to those who are most directly affected by the terms of reference and to manage the risks that would be posed to the orderly progression of these hearings by COVID. Those categories were set out again with much more detail in the practice direction, so this has been well known for some time. I perhaps should have made my reasons for doing that more clear, but I'll do it again now. It's not just the risk that someone may contract COVID-19 as to why I did that, but the self-isolation requirements are a very real and significant risk for this inquiry. Significant time and resources have been expended in organising these hearings. It is a very large and significant endeavour to organise more than 50 witnesses to come to give evidence over a 3-week period. It is a costly exercise utilising significant public resources, not just cash, I withdraw that, not just monies, but staff time. It also, thanks to the assistance that the council has given us, would put a burden on them in terms of making facilities available again. It's in the obvious public interest that these terms of reference be resolved as promptly as they can. Therefore, I am very concerned to ensure that these hearings do not become interrupted any more than they already have by the effect of COVID-19. COVID-19, and in particular the self-isolation requirements, has already had an effect on the orderly conduct of the inquiry. If one of the inquiry team members was to contract COVID-19 and self-isolate, it would almost inevitably lead to these hearings having to be at least delayed for not just a matter of a week, but to reorganise would take a number of weeks. I do not wish that to happen. It's for those reasons, and primarily directed to the self-isolation ones, although I would not wish anybody to contract COVID-19, that I made that direction. It's for those reasons that I propose to maintain it. It's brought to my attention over the luncheon adjournment that a member of the public has informed the inquiry of their displeasure with that ruling, and that a television news channel intends to be here tomorrow to report on what is seen to be the issue of public attendance in the inquiry. None of that alters my consideration of the issue for the reasons I've just given. I welcome the attendance of any television news channel, and as I've made clear this morning, I'll be willing to hear from them if they wish to be present in the hearing room. It's also been drawn to my attention that it's been suggested that the matter will be referred somehow to the Minister. Again, I welcome the Minister's interests in these proceedings, but ultimately it's a matter for me to determine the procedures for this inquiry. I am determined to ensure these hearings are completed without interruption, and in so doing I have adopted procedures that are consistent with those that have been adopted by courts and other tribunals throughout the state over the last 2 years. Finally, I'm aware that a view has been expressed to the officers assisting the inquiry, but by streaming the proceedings with limitations on those who may be present in the hearing room is anything but public. That is wrong. The public can view the proceedings. They are being live streamed, and nothing will happen during these public hearings unless that stream is live and active. A written transcript is being made available, and as soon as it is available to the inquiry, will be published on the inquiry's website. Exhibits, as they are tendered and if appropriate to be made public, will also be placed on the inquiry website. The public, therefore, has a much greater access to proceedings of this kind than they do of court proceedings. So to suggest that the proceeding in this way is anything but public, in my respectful view, is misguided. The directions I have made are given to ensure that the most directly affected by the terms of reference, being councillors, certain categories of staff, the council itself, the administrator, the current general manager, etc., can come and go as they please, as they should be able to. I well appreciate that some may disagree or be disappointed with my direction in this regard. That is their right. However, I have to balance that level of dissatisfaction, and I must say it is very small, at least as it's been brought to my attention, against what I see as my obligation to ensure the orderly and efficient conduct of this inquiry. I will not be addressing this issue again. I said this morning that I would not permit the public hearings to be delayed through non-compliance with the practice direction, and this has already diverted me from that, but I felt it important to put on the record given the approaches made to the officers assisting the inquiry over the luncheon adjournment. Given that apparently it's a matter of some significance that this issue will be taken up with the Minister, I direct that the transcript of these remarks be forwarded to the Minister for her information in the event that that referral, whatever form it may take, actually takes place. Mr. Parrish.
Thank you, Commissioner. I call as my first witness Steve Horton.
Yes, Mr. Horton is in the witness box.
Hi. Commissioner, I just ask your permission to refer to the submission put in by the Chamber of Commerce, who I am representing, because I've been given clear directions by the board that I need to adhere to what we wrote in the submission.
All right, well, shortly you'll be asked to take an oath or an affirmation, and your obligation here is to answer the questions of counsel assisting and me in accordance with that oath. So I'm sure that will accord with the wishes of your board, but that is your obligation today.
Thank you, Commissioner.
So Mr. Broad is just to your left, and he'll have you take the oath or an affirmation.
Horton, do you wish to take an oath or do you wish to give an affirmation?
I'll take the oath.
Right hand on the Bible. You swear the evidence you're about to give to this inquiry will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you.
Thank you, Mr. Horton. Mr. Parrish.
Mr. Horton, just as a matter of formality, could you please spell your name for the transcript?
My name is spelt S-T-E-V-E-N, and Horton is H-O-R-T-O-N.
And I hope for your sake you've never had to give evidence in a court before, but one of the problems we sometimes face is people nodding when there's a transcript. So if I could just ask you to ensure that you give verbal answers, I'm sure you will, but it's something worth remembering at the start. Can I just ask firstly for your own background, both in respect of the small business, the Southern Highlands Chamber of Commerce and Industry, and your residency in this council?
My wife and I have lived in this area for over 40 years, and we've had businesses in this area for 35 of those 40 years. Before that, I was a business development and improvement manager at a senior level for the New South Wales government.
Thank you. And what sort of businesses have you run over those 35 years that you were just referring to?
So we've run a secretarial service, we've run a retail outlet over in Berrima, and we've run an art gallery and retail outlet in Berrima as well.
During that time, have you had occasion to interact with this Shire Council and its predecessors from time to time?
I have.
Would it be fair to say that you have an experience of these councils stretching back 35 years?
Yes.
And in respect of the Southern Highlands Chamber of Commerce and Industry, of which you are the chair, can you give us some history of that organisation?
Approximately 9 years ago, a group of people met from the different chambers in the area, and we managed to amalgamate all but one, so that we had a stronger voice in the area for the chamber. I was part of that group, and initially I became the vice chairman, and after 4 years, after I'd run for the last council elections, I resigned from the chamber to do that. and then I took over as the chair after that. Been there for the last 5 years.
And when you say you amalgamated all but one, does that mean there's one other group or organisation which represents similar interests to you in the Shire?
The Mossvale Chamber of Commerce and Rural is still in effect, and it basically looks after the Mossvale area. There are numerous other groups in the area that represent businesses. I couldn't name them all, Commissioner, I'm sorry, but there are numerous.
Wouldn't ask you to name them all, but can you give me the names of a few of the other, in your view, significant groups who have a similar role to yours?
Are you asking me for registered groups?
That would be preferable, yes.
Registered groups, we've got people like the Business Women's Network. We've got Robertson Chamber of Commerce is a new chamber. They've only been registered for about 12 months. And really, the others, a lot of the others are not registered as such. They're just groups of people, most of them lobby groups.
Do you, at a general level, have occasion to share information or views with those other groups from time to time?
We do.
Thank you. And can you describe for me the types of businesses and industries that your members are engaged in?
We represent all levels of business in the area, particularly groups in the service industries, lawyers. We look after quite a number of accountants, financial services. We have a number of retail groups. We have a number of cafes. So we look after the broad spectrum of businesses in the area.
Thank you. Did your group take part in the Small Business Commissioner's report and the small business consultation of the Wingecarribee Shire Council last year?
We did. We were actually worked with Illawarra Business Chamber at that time to help commission that report.
Yes. I might just show you that report to both refresh your memory and to take you to parts of it.
Just before you do, Mr. Parrish, Mr. Horton, when you say you worked with that other organisation to help commission the report, what do you mean by that?
Illawarra Business Chamber, or they're called Business Illawarra these days, I'm a member of their Regional Advisory Council, and I spoke to their Executive Director when things started to sort of blow up in the area. We thought it was a good idea for us to get a higher level of research done into the area about how people felt. So Adam and myself and the two boards got together and we actually asked the Small Business Commissioner if he'd do that piece of work.
I see. And when you say things in the area started to blow up, I could cover a number of issues. About what time do you direct that comment to?
It was probably, and I really can't be quoted on this.
That's all right. As best you can.
But I'm sure it was just before the minister made the decision to stand the council down.
Thank you. Thank you, Mr. Parrish. To make it easier for you, the number is this Exhibit B?
Yes, Commissioner. Can I just ask, and I put this question either in your own view or that of your organisation, what you took to be the issues that were blowing up at that time that you were referring to just then, just either in your own impression or what you were getting feedback from, and you can distinguish it as you need to if you want to.
We had a number of businesses that were coming to us and talking to us about the inability to get development applications across the line, inability to make contact with certain members of the staff. There was a lot of talk in the area about infighting between the councillors. It wasn't up to us to make decisions on that. These were just things working through our membership. So that we felt that was enough for us to start looking to get. We needed to get an outside view, so that because sometimes it's difficult to get inside views. You know, it can be tainted because you're too close to it, and And the Small Business Commissioner was the obvious choice for us because that's his gig, that's what he does.
Thank you. So if I can take you to page 461 of that tender bundle, there should be numbers in the bottom middle which say tender bundle B and then give reference to a page.
Sorry, can you repeat?
461 is the page.
I've got it. Sorry.
Thank you. No, take your time. That's the paper wrangling we all have to deal with. But just for the purposes of identification, do you have in front of you the document which starts small business consultation, Wingecarribee Shire Council? Is that the document?
I do.
Okay. And that's the document you were referring to before. Thank you.
Yes.
And you've just given some evidence before that you were involved in the implementation of this report. Can you explain to the Commissioner how you and your members were involved in the consultation?
So the Small Business Commissioner did a number of interviews and did some public sittings in the area, and we were involved through that and also through Business Illawarra.
Were you happy with that process? Did you feel like you were given sufficient space and ability to provide your feedback?
We were.
And was there any other consultation prior to the suspension of either your organisation or as you knew small business in respect of a survey like this? Had this been done before?
Sorry, could you repeat that?
Sure. What I want to know is, at any other point during that 2016 to 2020 term, was there any other type of consultation or report like this that you knew of, or that you can recall?
No.
Just very generally, from your members' point of view, how did they view the level of consultation of yours and similar groups in the 2016 to 2020 term of council?
Sorry, I'm not understanding some of these questions. Are you asking what my members thought about our consultation with the council or their consultation with the council?
Their consultation with council at a general level.
The feedback we were getting from members was that it was very poor.
Was this something that was unique to that 2016-2020 term, or had there been an existing feedback that was similar? Do you recall?
Feedback we were getting is that this had been going on for quite some time.
Just going back a question, Mr. Parrish asked you a question about satisfaction with consultation. He may be coming to it, and I may be jumping ahead of myself, but in what context was this consultation happening? That is, about what issues were your members expressing concern about consultation?
We run networking meetings every month, and we were having a lot of our members come to those networking nights, and we were getting consultation through that. We were getting consultation via email, consultation via telephone calls. Yes. So our members, we worked really hard to get the membership to understand they could ring and talk to us. Yes. and tell us about the issues they were having. We didn't go seeking these things because we thought that really wasn't our role. It's actually, we felt it was better for them to come to us. And so we did. We had a couple of small workshops where we actually invited people to come to talk about some issues that were happening in the area. We did one with the Food and Wine Association around about a food and wine event. There was a lot of people came to that meeting, and they were all jumping up and down about lots of different things, and I can't remember everything that was said, but they were complaining about communications at that stage too.
Yes. So from that answer, I understand that you're able to get a wide range of views from the membership as to their views about how the council was performing at the time. Is that fair?
Yeah, as wide as you can get from a community like this.
Yeah, quite. I understand. And I may have misunderstood an earlier answer, but I thought you said that you got the feedback from your membership about consultation with the council was that it was poor. Did I understand
That's
you
right.
correctly? And are you able to recall any particular examples or issues that were driving those comments?
Most of the comments we were getting at the time were about development applications. There were a few other things, but development applications was the big issue. As you know, businesses, when they first start to try and put a business together, if they can't operate until that DA goes through, in a lot of instances, and that's money for them. And so, of course, when you start hitting that money nerve, people will speak out. And so we were getting quite a few calls about that, but not just from a business perspective. Some of our members also had personal DAs in for buildings, and they were having the same level of problems.
Thank you. Sorry to interrupt.
No, thank you, Commissioner. Can I just go back to this document specifically in the consultation that was involved with that? Am I right in thinking that there was both face-to-face consultations as well as written submissions, both with your members and members of other similar registered organisations?
That's my understanding, yes.
Okay. Can I take you to page 5 of that document? I'll start using the pages of the actual document rather than the tender bundle, because they've got problems on the black background. The page that starts list of recommendations. Do you see that?
Yes, I have it.
And that goes over the page as well. Do you see that?
Yes.
Now, that has been dealt with under 3 focus areas, and those 3 focus areas are also reflected in your submission to the inquiry. Do you agree with that?
That's correct.
Can you tell me, if you know, how those focus areas were arrived upon as topics, as it were, to address the issues which were addressed?
It was done by means of interviews and submissions.
Were you involved with the Small Business Commissioner in coming up with these areas, or was that something which, after you had commissioned the report, that was something which was left in their hands?
We were provided with the categories which we agreed with.
Thank you. And can I just take you to that first category, which is the focus area of improved communications and customer service? Do you see that?
I do.
Mr. Parrish, before you go on, I think you have to press a button to be seen on screen.
Okay, I've got my red light, Commissioner, which I thought was sufficient. If that helps.
I think that's done the job.
Okay. So we're dealing with this first focus area, improved communications and customer service. Do you see that?
I do.
Can you tell me what the Southern Highlands Chamber of Commerce and Industry's opinion of that focus area is? By reference to your submission, if you need to refresh your memory.
I don't need to refer to my application on this one. We've actually since spoken to the new management here about this. We believe that the single most important issue for this area is that there's a very clearly written down document that talks about how the council engages with stakeholders. Not one stakeholder, not some stakeholders, all stakeholders, so that everybody has to play off the same song sheet. That's what the Chamber had requested. We've requested it since, and we believe that that's what the Commissioner was trying to say here. Have a clear strategy for how you're going to engage, because up till that stage there was a feeling that senior management here was playing favourites.
Thank you. And do I take it from that answer that as far as you were concerned, there was no such strategy. Is that correct?
We'd never seen one.
So even if there was one, from your point of view, it wasn't implemented. Is that fair to say?
I can only say I've never seen one.
Okay. What was the effect on your members of this perception that there was a preference for some groups and no overriding strategy?
Well, when it comes to DAs, it was just simply a matter that if people had applications in, a lot of the time there was nobody to talk to.
Thank you. And you say in your submission that to date there has been a loose series of meetings with no formal structures put in place. Is that what you mean when you say that, in your view, there was a preference for some people and no overriding strategy? Or is that a separate issue?
No, I believe that's a separate issue.
Okay. Well, can you tell me, can you explain to me what you mean by there was only a loose series of meetings with no formal structures put in place?
Whether it's a misconception or not, one of the conceptions here, or views here, was that council were meeting with people that were forming lobby type groups, and that was actually having an impact on things, that development applications and other things that were happening in the area. Now, again, I can't state that that's true or not. It's a perception that we were getting through the chamber.
And you then state in your submission that members cited it has been difficult to maintain effective communications with council senior staff and councillors due to them not wanting to work with some and only prepared to work with others. Council should give their time to all sectors of the community and business. Has that been covered off by what you've just said, or is there anything you want to add to what you've previously just said about that?
I believe I've just covered that off.
Okay, thank you. In your view, was there anything in respect of the communications and customer service that the council did well or was notable as a strength of the council in this communications and customer service regard?
For me, personally, as the chairman of the chamber, I did have access to senior management when I needed from time to time. I tried not to have too much access with those guys because I worked for the government and knew how difficult time is to give up. But there were issues that we were trying to face at the time that we believed we were having difficulty getting people to listen to us. Yes.
Thank you. And the second recommendation on the list, which I think we've covered off to some extent already, is the focus area of enhancements to DA and other approval processes. Can you just explain what the Chamber's position is in respect of that focus area, and feel free to refer to your submission if you need to.
Yeah, again, I don't need to refer the submission on this one. I heard as late as 2 days ago, I had somebody wander into my wife's shop and tell me they still can't get DAs through. So that's a problem in this area. It has been for a long time, and it still is. And it's just stopping people from building, it's stopping people from putting businesses in place. And so our stance on that as a business chamber is, as an advocacy group for business, it's just not good enough. I'm sorry, but we need these businesses to be able to get up and running. We need jobs in this area, and that's our focus. And so we totally agreed with the Commissioner on this one, because we'd had people come to us about the fact that DAs couldn't get through, and as I said, I'm still seeing it even today.
Do your members have a view on whether the local planning instruments are sufficient to at least provide certainty and growth for your sector?
Commissioner, I can't respond to that because I've had no communications with my members about that particular issue. Sorry.
one of the recommendations was that and you can follow along if this will be of assistance, it's number 7 on the recommendations.
Yep.
That council review both its governance and operational processes to ensure that these are separate and transparent. Where there are reasonable delays, it should be evident whether these relate to governance or operations. In such circumstances, the applicant should be advised in writing of the reason for the delay and the next steps, and a timeframe associated with the assessment. Do your members have a view on that? Do you know, or do you have a personal view on that recommendation in particular?
I don't have a personal view on it. Again, I can only say that we're still hearing that there's issues.
Okay. Thank you. And is there anything in this DA planning approval space that you thought the council did well, or it was a strength of the council over at least the 2016-2020 term?
I really can't answer that. Unless I was actually part of that team, I would find it difficult to answer what they were doing well and not well. All I know is that we weren't getting DAs through.
Thank you.
Well, perhaps, sorry to interrupt, but perhaps the import of Mr. Parrish's question is we've heard from you there was a general perception that it was difficult to get DAs through. Were you hearing anything about what the council was doing well in the planning space?
I wasn't.
Thank you.
Thank you, Commissioner. On page 6 of the report, we have the third focus area, which is initiatives to build opportunity and small business development. Can you tell the Commissioner about the Chamber's view on that focus area? And again, if necessary, please refer to your submission.
Unfortunately for me, I was actually part of the Economic Development and Tourism Committee for the council over 3 terms. I'm pretty sure it's 3 terms. And I'm sure that if you looked up the minutes, you would see me being very boisterous about the fact that we hadn't had an economic development plan in place for a number of years. It's a very important instrument in these areas for economics, and it allows the Chamber then to build on that with economic growth, because our area is not so much to supply the area with that level of documentation. Our area is to help with economic growth with the businesses. But we need to have a plan that actually allows that to happen. And it was very unclear. And there was a whole bunch of lobby groups that were pushing particular issues at the time about what should be in economics. And we were, as a chamber, were disagreeing with those things because they weren't things that were going to offer the level of employment we needed in this area, or housing and all of those other things that go along with the economic development plans. So we totally agree with what the Commissioner was saying here, because I'm pretty sure that the previous document was completed in 2016, and so, no, it was earlier than that, 2010 I think it was, and we needed a new plan and we just didn't have one. Now there's a plan in place now, and I'm sure the council's working towards it.
You said you were a member of the Economic Development and Tourism Committee for a number of years. Do I take it therefore that the lack of an operational plan predated 2016 and was a problem with previous terms of council as well?
The plan that we had in place was actually coming to an end, but it was also outdated. Areas like this, you know, as your area grows, you need to be reviewing these types of documents. And just because a document's in place from 2006 to say 2010, you need to be reviewing those documents. And the Chamber had been pushing that for a number of years, and it just was not happening.
Thank you.
Sorry, can I just add to that?
Of course.
We didn't have an economic development officer here for a number of years. For whatever reason, they've had trouble employing people to certain roles here. That was one of them. And I'm pretty sure that position was vacant for a minimum of at least 5 years.
Thank you. Now, one of the things which the Small Business Commissioner concluded was that many businesses did not understand council processes or how decisions were made at council. Is that something which your members would agree with, do you know?
I would say most of our members would agree with that.
Okay. And if I can just take you to another couple of matters noted by the Small Business Commissioner which might not have been specifically addressed in your submission. Can I take you to page 18 of the Small Business Commissioner's report?
I have it.
You'll see the second significant paragraph down begins, several businesses and consultations expressed concern regarding the role and decisions of council's previous administration and councillors. It was noted that council staff would make recommendations in accordance with an established strategy or policy only for those to be overturned or rejected by councillors without reasons or advice to the applicant or the community. Further concerns were raised by businesses regarding role clarity, purpose and functions of council and councillors. I don't think it was expressly addressed in your submission. Do your members agree with that broadly? Are you able to tell the Commissioner?
I have had members talk to me about that particular issue, where they've actually seen something go through at a council meeting only to be later overturned, and then they've questioned that. I think my membership, I'm pretty sure my membership believes that if we meet all the criteria of the development process and we meet all the criteria of the local environmental plan, that these things should just go through. That's their understanding. So whether that's right or wrong, that's what they believe.
Thank you.
And just on that page that Mr. Parrish took you to, page 18, and that very paragraph, the second sentence, it was noted that council staff would make recommendations in accordance with an established strategy or policy only for those to be overturned or rejected by councillors without reason or advice, etc. Do you see that?
Yes.
Leaving aside examples of whether it did or didn't happen in that way, but if that was occurring, does that have an effect on the confidence that your membership might have in the council's processes?
Not just my membership, Commissioner, the whole community.
Yes, and what effect would that have?
They have no confidence because the tools are there for a reason. And if people believe they're not being used correctly, or people are actually changing things to suit whatever, if it's lobby groups or whatever it may be, the public loses confidence.
Do I understand from that answer that part of the thing that gives confidence in what's happening is some sort of predictability or certainty in processes and decision outcomes?
I'm going to have to agree with that because I come from an area in the government where that was my job, to put that level of stability within the government, to have proper procedures in place so that people knew exactly where we were going. And I know there's times when that can't happen, but you need to give people some level of confidence that people are following a process.
Yes, thank you. Thank you, Mr. Parrish.
I think you have observed that your members saw an ugly politicisation of the previous council. Can you just explain to me what is meant, or what your members feel is meant by an ugly politicisation?
I don't think I can answer that. I'm sorry. Everybody would have a different interpretation of that unless I spoke to my members directly about that.
Well, what about your personal view?
I believe, and I've said this a few times already, I believe that there are lobby groups within this area that have very set agendas, and they're lobbying towards anybody that they don't feel is agreeing with them, and they're lobbying against them. So to say it was politicised, I'd say that's probably true, but not by the chamber. That's not our job.
Right. And do you mean, I take it, politicisation in the alignment of interests sense rather than specific small registered political parties that we have?
Yes.
Thank you. Can you describe to me any other concerns or problems that your group identified with the processes of council outside what was addressed by either the Small Business Commission or in your submission? This is your opportunity to identify any other concerns that you or your membership had.
We were very happy with the work that the Commissioner did. We believe that it wasn't a political document. We believe it was actually that the Commissioner did the best he could to base it on fact. And we totally agree with that document. And having spoke to my members, and look, just to be on the record, I've actually stood down as the chair in the last 48 hours to let some younger people come in and take that role over. We'll get a lot more information back on this in the next few months now that COVID's over and we can actually start having our network meetings again, and I'm sure they'll come back. But at this stage I'd say that we just totally agree with what the Commissioner's written down there, and as a chamber we'd like to see us move forward now.
Okay. Is there anything else you'd like to bring to the Commissioner's attention, or anything that the Small Business Commissioner omitted that you think might be constructive in terms of the...
No, not at this stage. We're just very, very grateful that we were given an opportunity to come and testify today, and that we were given an opportunity to put a submission in and voice our opinion around the fact that we've got a great piece of work here, and we really would like to see that piece of work actually implemented.
Thank you, Mr. Horton. I don't have any further questions, Commissioner.
Just before you finish, I have a couple of extra questions. If you have the Small Business Commissioner's report still in front of you, do you still have that document?
Yes, yes.
And if you go to page 11 of that report, it's Exhibit B, page 471.
Yes.
At the top of the page, the Commissioner identifies some themes from feedback. Do you see that?
Yes.
I just want to ask you about some of the themes, and when answering this, if it's an answer that takes into account feedback from your members or indeed in your own personal experience, just tell me which view you're giving, and it may be a combination. But I just want to ask you about some of these things. The very first one, Council took an adversarial approach when dealing with small businesses. Do you see that?
Yes, I do.
Is that something either through discussions with your membership or your own personal experience came to your attention?
In some cases, yes.
And in what context?
In the context that when people were questioned on why changes were made, that wasn't always met with probably the respect that it should have been.
Yes, and changes to...
So when there was decisions made and then there was changes made afterwards,
I understand.
and when people then approached management, councillors, people were either didn't want to give an answer or basically just fobbed people off.
So I think you've answered my follow-up question is that a senior management interaction or a councillor interaction or both?
Both.
All right. The next one. Councillors and council staff have their own agenda which is different to ratepayers. Is that something...
I can't comment on that personally, but as I said earlier, that was a perception that our membership had, yes.
Yes. The third one, local economic development was not valued or its commercial assets appreciated. This perhaps ties in with some of your answers earlier about the plan. Is that the context?
We totally agree with that statement, totally.
And apart from the lack of plan, was there anything else happening or not happening which, to your mind, supported a view that local economic development was not valued?
As I stated earlier, there's a lot of lobby groups in this area that are pushing for different types of industries to move here. One of the things that an economic plan does, it actually gives you a balanced view of what should happen within an area that can actually seriously happen within an area. I mean, there's limitations like transport, accommodation, all of those things play a factor on. So really, at the end of the day, that plan, we have to have that plan because it gives people an understanding of where we're heading. It allows chambers to actually go and chase those sorts of businesses to see if we can bring them here and then help how we can actually grow them in this area. Things like, at the regional level, it's an opportunity for us to take, when the council actually say, okay, we're going to have this amount of business in this area, but the roads don't cater for it, we can take that down to the advisory council. It then goes to the state body and we can petition the state government to give us additional funding to actually fix the roads up. I mean, that's working together. And we need to see more of that.
And you've mentioned a couple of times the presence of a number of lobby groups. Do you have a view about how those lobby groups have affected decision making in the council from 2016 onwards?
Some of those groups are very, very aggressive, and they continually on the phone to the council staff. And Commissioner, I don't know whether you've ever been in a position like that, but when the people are continually ringing you, it can wear you down. So I'm believing that that's happening a lot in this area, and they are very aggressive, some of these lobby groups.
Thank you. The fourth dot point, DAs were required for minor activities. Is that something that affected your membership?
We've just been through this in the last week. We're trying to run a number of functions with the council staff, and the amount of documentation we have to go through to get anything done is ridiculous. Even little things like running an event in one of the plazas. The amount of documentation. So that's the sort of stuff, and it's the DA that's required. Yeah. So I suppose you can, from small businesses' point of view, the margins to make any money on any of these things are very small. And if you're actually spending a huge amount of time doing DAs and all of that sort of trying to get that stuff ready, it's difficult enough to get insurances for a lot of these things without that. So one of the things that we actually did say to the Commission is that we'd like to see these things streamlined. So we'd like to see some pre-approved DAs for certain things if you know there's going to be events in areas. So that's the sort of thing we were talking about in there.
And although you give an example of as recently as weeks ago, was that something that was persisting for a long time?
Yes. One of the things I remember vividly in my mind, because I had businesses in Berrima, was when we tried to put the Food and Wine Festival on in Berrima, and the rigmarole we had to go through there, and in the end we just basically gave up.
And did the chamber ever approach council to say this has got to be done a better way?
Yeah, we were working with the Food and Wine Association at the time, and yes, we did approach, and it wasn't going to happen. The logistics around it were just too complicated.
And was that an approach through the senior management?
It was a personal approach, and that's that meeting I said that we had with the Food and Wine Group. Yes. And yeah, it got very nasty, and we hope to never have another meeting like that.
Who was there from the council? Do you recall?
We had one of the assistant general managers. We had at least 3 of the councillors. Yeah, but we hadn't invited council to that meeting because that was a meeting that we wanted to have before we went to them.
When you say an invited council,
we hadn't invited any council staff to that meeting. Right. But yes, we had meetings about it because the whole idea of that meeting was to get our information together and then take it to council. But
when was this meeting? Do you recall?
This is
Best you can. It's not a
Oh, it's
memory exam.
2022 now. That would have been around 2019.
And so at least one senior staff member and some councillors.
There was at least 3 councillors there,
Do you remember
yes.
who they were?
I think Ian Scandrett was there. I seriously can't remember who the other ones were, sorry.
And I think I picked
And I
up,
could be wrong about Ian, so.
That's okay. I think I picked up at the tail of your answer, you hope never to have a meeting like that again.
Yeah,
Why
because
did you say that?
because our members got really, really upset, and they were saying things that I would rather that they didn't say in front of the councillors, and that doesn't help. See, I don't believe that confrontation is the thing that helps. I think we've got to collaborate on these things and work together through them. And just because you disagree with somebody, that shouldn't stop things from happening. You should be able to go and have a cup of coffee with them at the end of the day. And so I was very disappointed with that meeting. And Adam Zarth, the ED from Illawarra, was there, and it just got very messy.
I think you've covered the 5th point, that delays in response. The next one, council was generally unprofessional and not effective in planning for the future.
That's a very interesting topic. I wouldn't like to answer that because I've been at the other end of that, and I think that's unfair. But anyway, that's a personal opinion, not the Chamber's opinion.
No, I appreciate that, and what I was going to direct your attention to is the planning for the future. Did you see the lack of the economic development plan, I think you described it as, or an up-to-date one in any event is part of that?
That's a big document, and it's part of the future because your traffic plan, your housing plans, all of those plans run off the sorts of things that you're going to be bringing into the area. That's a planning process. And I've actually been involved in a couple of the council's planning processes, the one around the strategic community plan, which was a very, very well-run event. And it was interesting that that was the only time, I think, that everybody, business and the community, actually agreed on one thing, and that was to keep the green in between. That was the only thing I've ever heard those guys all agree on in a planning meeting ever. And I was stunned. I went back to the chamber and said, well, at least we got them to agree on something, which was great,
2 points further down, council kicked the can down the road on important challenges that needed to be addressed. Is that something that you were aware of through your membership or your own personal experience?
There are members that would agree with that. I don't believe that I ever saw that. I believe that they did take the challenges on, maybe not the way we wanted them to, and not as effectively as we would like them to have. But I don't believe that they just turned their back on it.
And the last point, high staff turnover in some instances, and the inexperience of council staff had a negative impact on small business. Was high staff turnover in council something that your membership was attuned to over a period of time?
We certainly were.
And doing the best you can, how long had that been the case?
That's been a problem in this area for many years. And it's one of the reasons that the DA processes were going off the rails, because we were having to hire contract people to come in and then contract people that don't know the area. Well, we're making decisions based on their understanding rather than people that actually are involved in the process regularly. And I don't think things are changing. I mean, we know you go and look in any business in the Highlands at the moment and they've all got wanted posters in their windows. So we're all struggling with getting enough staff. But that's a definite agreement on that one, yes.
Just over the page, onto page 12.
Yes.
This is some more in-depth commentary on feedback. Just under the heading transparency, do you see that?
Yes.
The first paragraph. Just have a read of that first paragraph to yourself and let me know when you've finished, please.
Yes.
So we've touched on some of those issues in terms of consistency and ease of things to happen, but what I wanted to ask you about was the comment, a lack of transparency and consistency led to businesses speculating there was favouritism in the prioritisation process. Do you see that?
Yes.
Is that something that your members had expressed?
The members did express that, yes.
And what to your mind was the lack of transparency?
Seeing DA decisions turned over, not getting an understanding of why that happened, decisions about, why certain things couldn't happen in certain areas, why you can have a festival in that area but you can't have it in that area, those sorts of things. And there's got to be reasons for those things. You just can't say no, basically. I mean, when you work for the government, you've got to be transparent on those particular issues.
And do you think that an explanation of why particular decisions are made or not made, as the case may be, if explanations of that kind were given, would it aid to restore the confidence in decision making?
I believe that would be go a long way towards actually helping restore confidence, yes.
Because tell me if you agree or disagree with this, but if a small business is sitting there wondering why they can't do something, at least if they're told why, they may not agree with it, but at least they've got the opportunity to try and understand it. Is that right?
There's that, but there's also, it allows us to plan and actually help these businesses overcome some of those things if they disagree with them. But you can't when you don't know why.
Yes. The next heading, decision making. And this is a similar theme, but just have a read of that first paragraph and let me know when you've finished, please.
Yep, sorry.
So the first example given is it could be that councillors didn't like an idea despite staff seeming supportive and the application satisfying the relevant requirements. Do you see that?
We had a number of members had come to us that had been to council meetings and actually seen recommendations go through and then they weren't accepted. So our members were questioning some of those things and saying, well, why? And not just, again, at a business level, but at a residential level. So they were coming back and saying, well, we just don't get it.
And that happening and then not being able to discern why, if I can put it that way, does that have an effect on business confidence operating in this area?
It does.
In what way?
Again, businesses don't want to put applications in if they think that the leadership is going to say it's okay. You've followed all the processes, and then when they get to the council meeting and it gets rejected, well, where's the level of confidence there?
Yeah.
So what happens straight away? You actually get a position where businesses don't want to go and go to the trouble of putting applications in. And that's not the answer for areas that are looking to have work to keep our young people engaged.
The second to last point I wanted to raise with you was on page 13. Do you see the heading communication and engagement?
Yes.
And there the Commissioner says businesses characterised communication from council as too little, too late. Do you see that?
Yes.
Is that something your members have expressed agreement with or agreement with that concept?
Yes.
And are you able to give some examples of where that's manifested itself?
Again, it comes, again, a lot of it is perception. And I said earlier in my testimony that that people were feeling that there was a level of favouritism in the area, and that's all boils it's all part of that process. And I think that single document would knock this thing out. One document that actually says, this is how we will engage with stakeholders, not key stakeholders, stakeholders. So that means every stakeholder, which is every resident basically. And it's a clear document then that should be made public, and the public should know what they've got to do to be able to engage with the council, and then they know the process. So whether it's actual or perceived, it's still there.
And finally, on page 14,
Yes.
there's a heading strategic planning.
Yep, got that, Commissioner.
And stakeholders advise their view that council strategic plans do not deliver clear thinking about the future, outline how outcomes will be achieved, or give appropriate focus to small businesses, which are rarely mentioned in strategic documents. Do you see that?
I have that.
We've discussed one type of overarching plan, but were there any other shortcomings in strategic planning that you would draw attention to?
This is the one that affected us the most, so that's the one that I would suggest that our members were focused on. But to see how all of those plans link together, because the strategic community plan, which is the blueprint for this place, and how this thing fit together. So that's the other level of confidence that the businesses need in this area, to know that the residents of this area actually agree with what's happening.
Yes.
And when you
Why is
see
that
some of
important?
some of the small villages, for example, Berham is a good example. There's a very, very active residents association over there, and we don't always agree. But we've now found a common project, and we're working on that common project, and that's made a huge difference. So that's the sort of thing that we need to see, how the villages and the residents and the businesses, because most of the businesses are residents anyway, but it's just about, how they think. And
Yeah.
so seeing how those documents all stitched together would be quite important to businesses, in particular for business confidence.
Do you think the community is divided in some respects between associations and business? And
Absolutely. Has been for many years.
is that just a feature of life in the Shire, if I can put it that way?
Basically, that's life in the Southern Highlands, and we've had to learn to live with that. And it's got more complicated over the last 10 years as we're seeing more people drift back in from the city, and the way people think. So a lot of people come here and they just don't want anything to happen. And that's fine, but when you're in business, you can't, life's not that simple. So, but I would suggest that most people in the area still get on, they just have differing opinions.
No, by divided perhaps was the wrong word to use, but I think you understood the import of my question, that there are people with divergent views about how things should be done here, and those views are very strongly held.
Very.
And not easily, common ground may not be easy to find. Is that?
You're correct in what you say, Minister.
Yeah, thank you.
Commissioner, sorry.
Anything arising, Mr. Parrish?
One thing, Commissioner, if we can take you back to the very start of the Commissioner's questioning, just back to page 11, the very first issue that the Commissioner dealt with you on was the Council's adversarial approach when dealing with small business. You described some disrespectful, I think you described it as interactions. I apologise if I didn't hear your answer properly, but are you talking about councillors there or senior staff or staff?
Both.
Both. Thank you. Thank you, Commissioner.
Mr. Horton, that completes your evidence. Before you go, is there anything else you would wish to draw to my attention or say before we excuse you?
Just to thank the Commissioner for giving us the opportunity to come and speak today, and good luck to you guys in getting all this stuff done. It's a big job over 3 weeks.
Thank you. Mr. Parrish, is there any reason Mr. Horton ought not be excused from his summons?
No, Commissioner.
All right.
Thank you, Mr. Horton.
Mr. Horton, that completes your evidence. You're free to go.
Thanks, Commissioner.
For today, no other witnesses today, Commissioner.
do you know, have any, withdraw all that, who's coming tomorrow?
Well, if I can just consult my
Yes.
officer for a second. And I think both as a matter of buying time while he limps out of the room, and also to give effect to something I said earlier on, we will be publishing this on the website, this list on the website, shortly after we rise here today.
Thank you.
At 10 a.m, Commissioner, we have Sarah Haslinger, who's giving a submission on behalf of the Friends of Wingecarribee, followed by John Barrett, who's giving a submission on behalf of the Friends of Bowral, followed by Nick Wilton in the afternoon.
So we have 3 witnesses tomorrow, and then Wednesday. Do we have a settled list for Wednesday yet?
Currently, the list for Wednesday, which I anticipate is settled, will be Jan Wilson, followed by Eleanor Sheehan, followed by Alan Olsen, followed by Mark Bourne.
All right, thank you. Well, as Mr. Parrish has indicated, those details will go up on the website shortly this afternoon. The transcript will go up once it's available for those who are interested. It does take a little time to get to us, so it may not be there by the end of today, but it'll be there, I hope, very early tomorrow morning, if it can't go up tonight. If there's nothing further, I'll adjourn until 10 a.m. tomorrow.
Thank you, Commissioner.